everyone, and welcome to Crime in Court. This is the 1993 Menendez brothers trial. We are rewatching it, some of us watching it for the first time, and this is in the state of California versus Erik and Lyle Menendez on trial for the homicides of their parents, Kitty and Jose. They admitted to doing the crime. However, it took some time, but if they finally came forward with the truth after they had been arrested for the crimes, that the reason was because Jose and Kitty had been essaying them. Specifically, Kitty had essayed Lyle, but Jose had been essaying both the boys. At least it stopped with Lyle, but continued with Erik until he was 18 years old. Started at the age of 6 for both of them. So you can only imagine the horrific childhood that Erik had and how fearful they both were of their father when every single person that came on the stand that knew the Menendezes said that Jose was a scary man. So you can only imagine how scared the boys were growing up in that house and having to live up to Jose's expectations. So let's get back to, we are on part 4 of Erik's closing argument. So remember, there are two sets of juries and attorneys for a set of attorneys for Erik and a set of attorneys for Lyle. They have separate closings. So this is the closing for Erik, part 4. This is going to be the final part of Trial Rewatch, and we'll have some recap and some special episodes later. But so we're gonna go through the final part of Erik's closing today, and then I'm gonna do a recap and talk about the verdict in this case, and then a little bit about the 1996 case where they did get convicted of the crimes. So, excuse me. We'll get started, and I rewound it just slightly a few seconds before we left off. She's talking about how Erik's memory might be a little off um, about going to the gun store to purchase the guns, but she's saying, that they'd never debunked the things that Erik had said. So here's her kind of repeating that.
And Erik knows this testimony's coming, and he could easily reconfigure his story if that's what he was going to do, and he didn't. And he also knows, obviously, that Mark Heffernan is going to say that he believes, although he has no schedule to prove it, that he gave him a tennis lesson on Friday rather than Thursday. But Erik remembers what Erik remembers, and that's what he testified to. And along that same line, I will talk about the reloading that occurs after Erik and Lyle shoot whatever ammunition they had in their gun. They both go outside, and Lyle reloads one round. Now, if Erik wanted to make himself look good, there's a lot of things he could have done with that evidence, not the least of which is forget it. But he could have lied. They both could have lied about that. There was no way in the world that the prosecution could have proved that they reloaded that one shell. There is no way in the world, because none of the neighbors heard a pause long enough to include that. When they testified, they heard what sounded like a string of firecrackers and then a pause of a second or two. Now, I submit to you, it did not take long to run back to the front and to load that shell in the panic state they were in, but it took more than a second. It probably took more than 5 seconds. And not a single person. And again, remember, we don't try cases in a vacuum. We know what people are going to say in advance. And he does too, because we tell him. He sees the report. So we know what the neighbors heard and what the neighbors didn't hear. And no one heard a pause that would account for the reload, and yet they testified to it. And there is no physical evidence that shows a reload was necessary. No matter how many times Mr. Kuriyaman may talk about the number of wounds do not equal the number of shots. And they can only prove 8 shots. And I think there were more than 8 shots, but I don't think there were 13 shots, which is what they'd have to prove. There is no evidence to support that. And so there was lots of room to run if Erik wanted to lie, because they could never prove through physical evidence there was a reloading. But it happened. And he told the truth about what happened that night. They ran out, and that shell was reloaded. And that's that. And Lyle even testified that he had extra shells in his pocket. But he was in such a panic state, he didn't even remember that. And he could have lied and said, to make it look less disturbing, that he reloaded from his pocket. But he didn't say that.
And I want to point out too that there's no, like she just pointed out, there's no proof that it was necessary to go reload. It's true. We don't know what Kitty's condition was. She might have been making, it could have been noises that they heard, but she might have already been deceased by the time they came back and reloaded. She could have, it could have been, she could have already been deceased at that point when they had shot her in the room and noises happen, gurgling and things like that can happen even after a body is deceased. So we don't even know that she was deceased when Lyle came back. And he even says he didn't look at her face when he shot her. So we don't even know that Kitty was still alive when Lyle came back into the room and shot her point blank. We don't know. And everybody, I want to point out too that that is like the one point that, like, if you ever listen to an interview, or by the way, there was just a 2020 special on, it was very still biased towards, the boys are guilty. And Keith Morrison, or no, was it? Yeah, Keith Morrison was on there. So no, it was Dateline then. Sorry, it was Dateline. I'm getting myself confused. It was a Dateline. So Keith Morrison was on there talking about how the abuse happened, but it wasn't that bad. Like, what are you talking about, dude? You live in that house. So it kind of made me angry on a lot of counts, but there were some good points to it if you do go back and watch it. It's not that egregious. It does point to the abuse and talk about that with the boys. So, all right. So, what else was I going to say? The Dateline thing. I don't remember. Sorry. I'll think about it.
So, as I believe Lyle testified, when they knew that they would be telling the truth about their lives, they were going to tell the good along with the bad. And that's what happened. And it's for you to judge whether.
I just remembered. Okay. So, sorry, I'll go backwards. So Pam Bazanich was on that Dateline, and they interview her all the time, whenever there's some kind of Menendez special. She's very reachable, apparently, and she's very bitter, very angry. For some reason, she despises these boys, and she always brings up the fact that Lyle went back and reloaded the gun and shot his mom in the face point blank. Like, that is the one thing that really offends her. She brings that up constantly. Like, this woman is bitter and crazy. And every time that she gets a chance to make a public announcement or statement about the boys, she's constantly putting them down and saying she doesn't believe them. Everything was fabricated. She believes that they belong where they are, and all the abuse was fabricated. And it's like, really, lady? Seriously, do you even realize how much evidence there is proving it, to corroborate it, rather? And in a lot of abuse cases, there's like a fraction of this, if any, evidence or corroborating, circumstantial evidence. It's very rare to have this much, but she thinks they made it up. Okay, Pam. All right, let's go back.
So, as I believe Lyle testified, when they knew that they would be telling the truth about their lives, they were going to tell the good along with the bad. And that's what happened. And it's for you to judge whether the fact of that reload in the panic condition they were in has any significance whatsoever. But the fact is they told you the truth about it, and they didn't have to do that. No one would have known. As the prosecution was so quick to point out, which is so obvious, it's meaningless, but no, Kitty and Jose Menendez can't get in here and talk about how they molested and abused their kids. They would have never admitted it anyway. But no, they are not allowed to refute. The problem is they couldn't have refuted if they were alive. The fact that these things happen is why they're not alive. Now I will talk briefly about Craig Signorelli. The purpose of Craig Signorelli.
Exactly. Like, that's the point right there. The point is they were doing these things to the boys, and that is why the boys did what they did. And that, I mean, the parents never would have fessed up to what they were doing. They never would have taken any kind of accountability. If the boys ever did try to tell anybody in the outside, I think that they would have gotten repercussions like 10 times worse than their normal punishment. So they didn't have anywhere to go or anyone to turn to.
His testimony has to do with the lying in wait special circumstance, and I have not gone in detail about the special circumstances, nor will I, because they're very, very long instructions, and I honestly cannot conceive of us being there. Maybe you can, but I can't, and if we are, I think you can follow the instructions without my having to take you through it. But there's a couple of important components about the lying in wait special circumstance. Mr. Curiano talked about some of it, but he left out this part, that there has to be proof of a substantial period of watching and waiting, not just a look or a peek. but a substantial period of watching and waiting, and then taking action in a continuous from that period of watching and waiting in a place of concealment. And that's what the law requires. And their entire purpose of putting Craig Signorelli on the witness stand was for him to testify that he remembers, never having written it down, mind you, he remembers that Erik said that he peeked in the door and saw his father sitting on the couch. Now, we know father wasn't sitting on the couch from what I've just shown you. But beyond that, how do you analyze that testimony? First of all, as you know, Craig Signorelli first tells this story on November 17th, 1989, to Detective Zoller up in Santa Barbara at the Baker Square restaurant. And when he tells him the story, he tells him that when Erik tells him this story about him and Lyle shooting their parents, he tells it in such a way that it's not real. He says he conditions it. It could happen. He tells it like a mind game. He is spinning a story. That's what he tells Detective Zoller on November 17th. And nevertheless, and he tells us now, I did that because I didn't want to bring down my friend. But 12 days later, he's wired for sound by the police, and he's very loath to tell us how they wired him up because, after all, that's police procedures. Am I permitted, he turns to the judge, am I permitted to talk about that, judge? That's police, little junior G-man on the witness stand. Well, okay, yes, you can tell us how you were wired up by the police, Mr. Signorelli. I know you're very important, but you can tell us anyway. And so here he is. He didn't want to bring down a friend, but he wants to get him on tape for the police. Because I suppose it'll make a better chapter in the screenplay that he told Mrs. Cohen he was writing, or in the book that he told Doug Doss he was promoting, which he hoped to make $1 million off of. So I suppose he thinks this will be very useful to his future as a senator. He, by the way, is the one who's majored in theater arts in college, and he tells us he did that so he could star in his own political commercials. So I guess this is a dress rehearsal for his political commercials. Young Mr. Signorelli. Mr. Signorelli, I suspect, is a rather troubled youth. And this is a case about troubled youth, so in spite of the fact I'm being kind of sarcastic about him, I think he's a very troubled youth, and let's leave it at that. But the fact of the matter is that he comes in here and he testifies, and let me go back to November 17th. On November 17th, when he tells Detective Zoller that Erik tells him this story, he doesn't say anything about the computer people. Not a word, okay? He doesn't claim to have been there on the day the computer people were there. That piece of his story does not emerge until March 7th, 1990. Now, what has happened between November 17th, 1989 and March 7th, 1990? Well, maybe he hasn't gotten a good enough offer on his book or on his screenplay. But the other thing that's happened is he's wired himself up, and he's gone out to this dinner with Erik, and he has tried his best during the course of that dinner to get Erik to talk about killing his parents, or to get Erik to talk about anything that would sound negative. And he is the one who suggests that they should talk about a company like the BBC. Those are Craig Signorelli's words. And if you want to hear that testimony reread, you don't have the transcript, but it was a very poor quality tape. But you can hear his testimony. It is he. And between him and Detective Zoller, this thing was patched together for you by way of testimony, who suggests, when Erik is talking about dreams for the future and a company that would do apparently everything except fry fish, that Craig says, you mean like the BBC? Okay? This is Craig talking. You can see why a kid like Craig would talk about things like that. I mean, he is a very grandiose young man. All right. And during the entire course of that conversation, he keeps trying to lead Erik into talking about killing his parents. And when he won't let go of the subject, and Erik testified about this at great length, line by line. And if you really want to know what went on in that conversation, I suggest that you listen to that portion of Erik's testimony again. And finally, Mr. Signorelli starts to talk about writing a screenplay about the killing of Mr. and Mrs. Menendez. And Erik says, don't fuck with that. And he says it over and over again when Craig keeps trying to bring up, but wait, we could talk, but don't fuck with that, he says. And then Craig makes some reference to the fact that Erik has talked to him about this before, and Erik says, I should never have joked with you that way. You know we didn't kill our parents. And why does Erik deny it now to Craig, when he also testifies that he indeed suggest to Craig in this sort of not quite real way that he and Lyle were responsible? Because he sort of knows that Craig is talking to the police, and he's suspicious of him, okay? And he sees that Craig is trying to lure him into making these statements. So that's where that conversation goes nowhere, and in fact it goes so nowhere that at the end of it, Craig says to the police who are listening into his lapel, gee guys, I guess that didn't help you much. This is the young man who didn't want to bring down his friend, he tells us, okay? So let's go back then to what value there is in the statement he says he got from Erik Menendez. We know it isn't important with the physical evidence, but beyond that, let's assume hypothetically Erik spun this yarn for him, which is what it sounds like. Did he get it right? Did he get the details right, Mr. Signorelli, when he's being told this story? He never asked any follow-up questions. He says that himself. He didn't ask why. He lied to the police on November 17th when he told them he wrote it all down in his school notebooks, what Erik had told him. So, eventually, being conscientious policemen, they get a search warrant for his house to find the notebook in which he wrote it all down. And lo and behold, he didn't write it all down. They got the notebooks, and there's nothing in the notebooks about Erik's confession to him. And he sits here on the witness stand, Mr. Signorelli, and he tells you, oh, I didn't mean I wrote it all down. Well, he doesn't quite say that. He basically says he didn't tell Detective Zoller that he wrote it all down. I intended to write it down. I told him I intended to write it down. And I said, do you think they're going to issue a search warrant because you intended to write it down, or because you told them you did write it down? Well, I told them I intended. I was writing it down. Well, blah, blah, blah. He lied to the police. He didn't write it down. And so how accurate is his recollection? And how trustworthy is his word? Now, he says, and we've gotten to an awful lot of litigation over a very small point, which is what happens in trials. He says that he was there when the computer people came. Erik says he was not, but I told him about it. And that, I suspect, is why he has such a strange story about them. Now, it doesn't take much to tell someone, yeah, a computer guy came and he had a pregnant wife. And he kept looking for this thing in the computer, and it took a couple hours and he couldn't find it, and that's when I found out. This is Erik talking to him, I suppose. That's when I found out my brother had somebody there before who erased the computer. The whole business about erasing the computer has no significance with respect to Erik anyway, because he didn't do it. Okay, it's Lyle who did that, and Lyle explained why he did that, and even that has no significance because there never was anything in that computer that could have made the slightest difference. Something in a computer is not a will. Carlos Baralt knew that, discussed that with Lyle. The relatives who first found that file knew there was no information in the will. They tried to get it. Joan tried to get it. Pat tried to get it. We're all sitting there playing with the computer. So none of it has any significance. I don't know how many weeks of testimony went into this issue. That absolutely has no significance. But to get back to this, the Haymans, that very attractive young couple, came in, and he was the computer expert, and she was the once pregnant wife. And I'll tell you just a tiny story. When we went to interview the Haymans, all this happened, right, 4 years ago. We go to their house, there were 3 little kids.
Counsel, let's stick to the record here.
It tells you about the passage of time. In any event, here are the Haymans, and they tell us that they saw someone on television in one of these programs about the case, and most of you saw something on television about this case as well before you became jurors, and they decided, or that person on television was the person that they had seen on the house, and that person on television was Craig Signorelli. But the problem with that is the way they described the person who was in the house. Now, Casey Whalen wasn't on any of the television programs. I don't think he wants to be a senator. He isn't majoring in theater arts, and he doesn't have as desperate a need to be at the center of attention, so he didn't get involved with the television programs. But he fit the description that the Haymans gave of someone who was heavier built than Erik, of someone who had sandy hair. Now, Craig Signorelli, there's been testimony, was smaller than Erik at that time, thinner, and always had pitch black hair. And when they talked about someone who was medium build, shorter than Erik, and light hair, that matches Casey Whalen, and not Craig Signorelli. And the Whalen family remember that they were having discussions. Remember this dinner on Friday night. And his sister was absolutely clear it was Friday night because that was the last day she worked, and it was after work. And this was the Labor Day weekend, and she didn't go back to that job, okay? So they remember Casey and Erik talking about having been at the house and discovering that the computer had been erased. Now, there was all this confusion about whether Erik came back August 31st or whether Erik came back September 1st, and he testified on cross-examination. He's not sure when he did. And Pat Heffernan testified he was in a daze, and he left half his clothes behind in the hotel room, okay? And I don't know. Did he fly on the 31st? He went to the airport. The ticket was used. Did he fly on the 31st? Most probably he did. So, if that's true, how could, Casey Whalen have been there on September 1st? Because they went back the next day to get Erik's car. And I suggest to you, and you know Casey Whalen had no particular reason these past 4 years, until he realized he was going to be a witness this past summer. He had no reason to try to remember specifically what day. And what his mother and what his sister remember is that he did indeed pick Erik up at the airport, and that they did indeed have a dinner where the erasing of the computer was discussed. And Katie, the sister, can date that dinner. But that does not mean that the picking up at the airport and the thing with the computer had to have happened on the same day. Remember, Craig Signorelli gives no details. He can't describe the Haymans. He can't describe any conversation that went on between Erik and the computer person. He doesn't remember the phone call to Carlos Menendez that Mr. Heyman talks about, which was an animated and loud phone call, because it appeared Carlos Menendez was somehow blaming Erik, and Erik is explaining I had nothing to do with it. It's not there, whatever we were looking for. Craig doesn't remember it, and Casey doesn't remember it. Craig doesn't remember doing anything around the house when the computer people were there, and Casey doesn't remember it. It's not something anybody should remember the details about, okay? And their memory on that score is exactly the same. All right, so that doesn't prove who has the superior memory. And the only other thing, of course, is Craig then proceeds to tell you that Erik is telling him this story. I mean, maybe I would have been better off not challenging Craig Signorelli at all, because what does he say? Erik is trying to find a will that partly disinherits him. He claims that Erik told him, yes, I'm looking on this computer for a will that leaves money to the company and less money to me and Lyle and money to some third class. And Erik says he never told him that. That's one of Craig's creative writing exercises. He's a big-time creative writer. Writes books, writes screenplays. In any event, that was the whole, and that is the whole, and that is the total significance of Mr. Signorelli, is this notion that he somehow informs the lying in wait special circumstance. But of course, he really doesn't, because he cannot and does not fill in the necessary element of a substantial period of watching and waiting. He also said, by the way, that he was at that house hours before the computer people arrived, and we know from Mr. Heyman's testimony, with Erik, we know from Mr. Heyman's testimony that there was this crossed signal. He gets to the house, nobody's heard of him, Erik's not there, he goes away, he comes back, and he calls again, and he's told Erik has just arrived, and he gets there immediately. So that's inconsistent with at least the sequence of events. And then the other thing here, which I will point out, is this. He testifies, Mr. Signorelli, that he sleeps over that night, Friday night, September 1st, okay? And he testified that he slept over in one of the guest bedrooms upstairs, and you heard from Ed Fenno, there are a number of different colored guest bedrooms. His bedroom in the house was the gray bedroom. And if you look at the photographs, there are 2 other guest bedrooms. One of them has the animal fecal material on the floor that the Beverly Hills Police took a picture of. And the last one, I think, is a room that's mainly, and that's a green and white room, and then there's an orangey type of room, okay? That's what his testimony was. Well, as you know, we went out in March and interviewed the security guard who was on duty overnight on September 1st. That was Antoinette Browers-Loden. At that time, her name was still Browers. We interviewed her. Ms. Erdely, who takes contemporaneous notes of her interviews and then keeps the notes and writes up a report, went there with the work schedule, which is here. And she sat down with her and showed her the dates that she worked, and they're highlighted on this schedule in shocking yellow, and went through with Ms. Browers the fact that she worked only one overnight shift at all during her whole time at the Menendez house, and that was the night of September 1st, and then she worked 2 or 3 morning shifts when she'd get on duty at 8 o'clock. And Ms. Browers was very specific with Ms. Erdely, that one overnight shift, she remembered that when she got there, the guard on duty said there was nobody in the house, and that she saw nobody in the house. And the next morning she saw nobody, meaning no family, only another security guard in the house. And she was real clear and real firm on that with Ms. Erdely in March of 1993. And she also said that on one of her later early morning shifts, and her next early morning shift was September 7th, the following Friday, when Erik testified Craig was at his house. The following Friday, she remembers seeing a friend of Erik's there wearing jeans and a t-shirt. And that is what she said, and that is what Ms. Erdely wrote down and wrote up in her report. And in comes Ms. Browers, Lieutenant Browers, and gets on the witness stand and testifies that she hasn't seen her work schedule, and testifies that the night of September 1st, Erik had a friend stay over, and she saw them the next morning in robes and pajamas, and that's the new testimony here. As I told you, it's fairly revolting how many people will come into court and lie. But her prior statement, which was carefully recorded by Ms. Erdely, her prior statement comes in as an inconsistent statement, and it comes in for the truth of the matter asserted. And you will be so informed that if you decide what she said to Ms. Erdely is the truth, you can accept it for the truth and not just to show that she's given different stories at different times. And she claimed here to be very fuzzy in her recollections, and if you want to hear all of her testimony again, that too can be reread. Now, I want to just address, I've already addressed in my previous remarks the evidence that the people put on in their rebuttal case. And you can recall the marvelous start that case had with Mr. Valentine and then Ms. Browers-Loden. And at some point, Mr. Walker, and then Uncle Brian, and Jamie Pisarcik. And I've already addressed Jamie Pisarcik, and I want to get back for a moment to Uncle Brian. I thought Uncle Brian was a fascinating witness because he couldn't and didn't contradict or controvert what we had already heard about his sister. But he tried to contradict what we knew about how his sister dealt with losing. I'm putting this up again because I want to actually take you through the testimony of Pat Anderson. Mr. Kuriama relies on Pat Anderson to prove that Erik said shut up, and yet put on Mr. Anderson, who told a very different version of these events. I'm not sure I have my small version, so I'll read along here. Okay, now what's happening here is she's describing at the top of this how very, very upset Jose is getting while Erik is playing in this penultimate round at Kalamazoo. She says, and he was moving closer to the net, this is Jose, or the fencing, and with that he was getting louder by giving his commands to Erik, and the officials were called. Now Brian Anderson says Jose is doing nothing worse than just sitting in his seat giving these illegal hand signals. He denies that Jose is saying anything verbal. He denies that he's walking down closer to where Erik is playing. What the officials do, the officials came over and told Jose that he should sit down, and he was not to be near the courts, that it was not permitted, and that he was not to give any kind of directions, that he was not to coach, and that he was the father, and the father knew what the rules were. The rules were to sit down and be very quiet. And did he sit down and become very quiet? Well, the official left, and Jose sat down for a minute, got up and left and did not listen to what he said, and proceeded to go back to the court area, which was right next to the court area there. Did Erik win or lose? He lost. What happened after he lost? There was one other incident that I should tell you about, too, there that happened other. And Mr. Kuriyama objects. And the court tells me to ask the question. Not me, Ms. Lansing. And Ms. Lansing says, was there another incident that was of significance to you? Yes, there was. Tell us what it is. What had happened was that after the official left, and that Jose was then giving more directions, Erik was in such an emotional state that he turned around and told his father to shut up. And he said it very loudly. And it stopped everybody around the whole court. Now, you may remember Brian Anderson tells the story very differently. He says, that not that Erik says anything in the middle of play because Jose is haranguing him with these directions. He says that it's after it's over and Erik has lost and Jose has gone over to talk to him, Mr. Reasonable Man, going to talk to his son to communicate with his son. And it's at that time that Erik says to Jose, after play is over, shut up. But this is how Pat Anderson remembers it. And it's a very dramatic event, which is, I suppose, why she remembers it. Okay, and he said, stopped everybody around the whole area. So there were games going on. There were like 15, 20 games going on. And what had happened was it was so loud that it shocked everybody. And Jose, with that, then threw up his hands and just said, I'm washing my hands of everything. I don't want anything more to do with him. I can't stand this. He doesn't listen to me. And he said, that's just it. Now, maybe this is the opening round in the declaration of war. Kitty, in the meantime, keep in mind, Karen Farrell, where winning and losing don't matter. Kitty, in the meantime, sitting next to me, was just a nervous wreck. I mean, she had the tenseness of gripping her hands and grinding her teeth to the point where she was actually white from nervousness. And Miss Lansing points out, you just made 2 fists, and the answer, 2 solid fists. And then, I cannot do the exact, but she would just grind her teeth like that, and that's how she was. But she was also very, very, very white. Because by that time, she had been holding her breath and everything because of this incident that had just gone on. Erik had then lost. And then, in the meantime, Jose had just left us for just a few moments and came right back, only to discover that, of course, Erik was losing. And he was then very, very upset. How did he demonstrate that he was very, very upset? He went into the court and he actually was pulling Erik out of the court and just even left his bag and everything on the court and was so upset with him. And then I was sitting right there, and as the door was right there in front of me, I was going to go up to Erik and say that, he tried his best. He really did try his best. But with that, Kitty pulled me back again, the same type of thing I experienced many times with Lyle when we had gone to the different meets, that I was not to go up and talk to Erik at all because his father was there. You remember Brian Anderson's testimony? Kitty ran over to her son and consoled him that he had lost. Did you feel sorry for Erik? Yes, I did, extremely. He was like a little bird that lost his wings. He was very upset. And he was scared. And the fright in his face was you just didn't miss it. And what's he scared of, folks? It was there. Jose pulled him off the court and pulled him right across all the other courts and took him up the stairs. We were on the lower level of the tennis areas, and he pulled him up. By that time, Kitty went out to collect everything off of the tennis court, and we then followed. Now, in either of these circumstances, because Mrs. Anderson had described a previous year when Lyle was playing, and a very similar thing had happened. In either of these circumstances, did Kitty try to step in and intervene between Jose? No. And I think either one, and the transcript says either one of Erik, but I'm sure that the reporter Erik should have been Lyle or Erik. And the answer, never. So she went on the court and she collected everything, and we then followed her, and we went to the vehicle that we were in. And what happened then? And then we went back to the hotel. Were you all staying at the same hotel? Yes, we were. Usually what happens is that we always went to support the boys in the meets in Kalamazoo because we lived in Chicago at that time, and what would happen is Kitty would get us, and what she means by that is they didn't live in Chicago. You heard Mr. Anderson testify. They lived in Downers Grove since 1970-something, but she's divorced, and she lives in Arizona now. So I think that's what she means. And what would happen is Kitty would get us a room not too far from their room on the same floor. So you all went back to the hotel room. Yes, we did. Was this in the morning or late? And that's all I put on for testimony. And you recall that what she then goes on to talk about, which I talked to you about earlier in the argument, is what happened around dinner and Erik not coming to dinner. So this is what's going on that summer, and not any misbehavior on the part of the defendants, on the part of Erik and Lyle that they're reacting to. This is parental warfare and not business as usual. Parental warfare that's escalating. Why? Because he lost a tennis match. And in that family, that's enough to bring out extreme behavior. I'm going to take this down because there's one thing on here. And this is Dr. Cox, and I'm going to get to this in a minute. Now, I'm sure that Mr. Kuriyama will get up and say that I have engaged in character assassination of Jose and Kitty Menendez, and I'm trying to distract from the issues of the case. So let me read you some instructions. Because the fact of the matter is the aspect of the character of Jose and Kitty Menendez that I have been talking about is properly before you in this case, and in fact is the basis of certain instructions that you're going to get. It is not only relevant, it's critical in order to evaluate this case. And here are the instructions that you're going to get about this. Evidence has been received which may tend to show that the decedents engaged in acts of violence and abuse on occasions prior to August 20th, 1989. Such evidence may be considered in deciding whether the defendant had an honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury or the commission of a forcible and atrocious crime. You are also going to be instructed that one who has received threats against his life or person made by another is justified in acting more quickly and taking harsher measures for his own protection in the event of an assault, either actual assault or threatened assault, than would be a person who had not received such threats. If in this case you believe that one or both of the deceased made prior threats against the defendant, and that the defendant, because of such threats, feared greater peril in the event of an altercation with one or both of them, you are to consider such facts in determining whether the defendant acted in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury.
Based on that reading, how could they have not gone with that charge instead of this trial they're hung. This it got very contentious and very people were angry and bullying others, and it went on for I think 16 days for Eric's jury. We'll read about it. But they really could not agree on it. It was like, I want to say half and half, where like basically the women believed the brothers and believed the abuse and wanted to go for one of the manslaughter charges. I can't remember. And then the most of the men wanted homicide, murder charges against them. So it was very split down the middle that way.
So the issue isn't character assassination. The issue is what were they like and what did they do? Now, if I stick to this, I take less time and ramble. Ooh, all those pages gone. Okay. Now, there are some things that Mr. Kuriyama mentioned in his opening that I haven't addressed in my remarks to you. Most of them, I think, were covered just in discussing the evidence, but I'm going to go back and see if there are any things that as yet are not covered. He was trying to talk about the good qualities of Kitty Menendez and the good qualities of Jose Menendez, and I've addressed that briefly, but let me just say this. If Jose and Kitty Menendez had married and had not had children, then I think there would be a completely different way of looking at them. They both had many personal qualities that we consider positive, and I've mentioned what some of them are. And I can imagine that if Jose Menendez, without children, in his particular style of dealing with people, which was so power and domination oriented, could have lived a perfectly successful life, taking out this need to dominate at the office and on his wife, and none would have known and nothing tragic would have happened. And if Mary Louise Menendez had fulfilled her early desires to have a career and to have an identity based on her own accomplishments and not just be the wife of a successful rich man, she may have had a happier life and there would have been no tragedy. Because these are not, in an absolute sense, the worst people in the world. They are just people who never, ever should have had children. But they did. And that's where the tragic part happens. Because whatever their pre-existing problems, whatever their backgrounds that led one of them to be such a power junkie and the other one to be so angry at life, whatever that was, all of that dark side came out towards their children by the fact that they had children. And that's really the tragedy here, that they're not totally worthless individuals at all. It's just that they set in motion, by being so terribly wrong to be parents, the series of events that eventually killed them. I guess I will just give a passing remark to the BBC. I guess when you run out of any other theory that the money did, they did it for the money, or they did it for hatred, or they did it for control, I guess now it's the movie made me do it. And that's such a strange idea, particularly since I don't know, and Mr. Curry, we don't know, either the prosecution nor the defense has any idea if any of you saw that movie, the BBC movie. Okay, now you're supposed to decide this case based on the evidence presented in the courtroom. And so I have no idea if any of you are walking around with the facts of that in your head or what that does. But I can talk about the evidence. And there is no evidence presented in this case that shows that this beat, first of all, that Lyle and Erik were together at the time the movie played. There is evidence by his own testimony that Erik was in Florida on the 30th and 31st, but there is no evidence that Lyle was. So the fact that the movie showed in Tampa doesn't tell you very much. Beyond that, there is no evidence that there is any facts in that television movie or even in the real life story and cases of the Billionaires Boys Club that bears any resemblance to anything that happened here. Okay, so it's just a totally specious notion, and it is an Ozialism. And the reason we know that, finally, is through Jude Smith's testimony. And just this little piece of Jude Smith's testimony, I think you can completely rely on because she's got the phone records to back it up. She says that Dr. Oziel was, she tells us that Dr. Oziel was completely familiar with the Billionaires Boys Club movie because he was watching it on the night of the 31st, and she's on the telephone with him, and he's talking to her about it, and there's her telephone record, which shows she is on the phone to his number. Okay, or he has called her. It's from his record. It shows the length of the call, and it is during the time that the movie is showing. The movie shows from 9 to 11, and this is 10:36 or 10:26, something like that. And the phone record is in evidence. So the notion is Erik Menendez didn't tell Dr. Oziel anything about a BBC movie. When Dr. Oziel's trying to put this together, he remembers full well, because he watched it, that a few weeks before the parents were killed, that movie played, and in his desire to set up his little blackmail scheme, he plugs that in, period. It is also, I submit to you, a ludicrous idea that Erik Menendez would see this movie and suddenly the light bulb, gee, Dad's bad, I should kill him, which is the theory of that. For one thing, I don't think it works that way. I mean, he's living in America, in a television world. I don't think the idea that a child can kill a parent has to come from a movie, has to come from that movie in which you don't have any evidence that the child in that movie actually killed the parent in that movie. The only thing you know, he was somehow involved in the killing of a parent. And I can't talk to you about the facts of that movie because they're not before you. And if you have them in your head, I don't know what you're supposed to do in the jury room with them, because I guess you can't talk about them either. I don't know. I don't know how you're supposed to handle that because it's such a specious piece of evidence to begin with. But just to put it to rest, why would Erik Menendez have to see a movie about the BBC to inspire him to kill his father? This is supposed to be the operational event because the people have no crisis. Without the revelation of the molestation secret, people have no reason why this family is in crisis so that this could happen, okay? Erik Menendez went to school with a young man named Brian Eslamina. It is Brian Eslamina's father who was killed, theoretically, by members of the Billionaires Boys Club, okay? Erik knows him. And he knows him from 1988. And he knows this family's story. And he's always known it since 1988. And obviously Craig Signorelli knows about the BBC, and he doesn't even go to Beverly Hills High School, okay? So this is a known thing. So how in the world, if he already knows Brian and he already knows this family, would this movie on July 31st mean anything whatsoever? Well, obviously it wouldn't. That can't be the causing factor here. That's nonsense. But it certainly appealed to Mr. Kuriyama because he brought it up at every opportunity in this case. The other thing Mr. Kuriyama said in his opening, which is not based on evidence, is he kept talking about how the brothers, this indistinguishable mass, threatened Dr. Oziel. And there is not one shred of evidence, and never has been, not even in anybody's previous memory or anybody's previous inconsistent statement, that Erik ever said anything threatening to Dr. Oziel. He went to Dr. Oziel because he was on the verge of suicide. And Oziel did testify. Erik never threatened me. Erik never said anything threatened. He chose to have somebody in his office to listen into his patient for whatever his reasons were, but not because Erik had threatened him. And that is clear. It could not be clearer. Erik never threatened him, but the prosecution has a great desire to paint Erik with this black brush, even for things he never did. Mr. Kuriyama fantasizes and speculates that there was some kind of conflict in this family because Erik didn't want to follow the rules of the family or toe the line. Which rule is it that Erik didn't want to follow? I'll tell you which one it was. Get on your knees. That is the family rule he did not want to follow. And there is no other rule that Mr. Kuriyama can point to that Erik violated, either that summer or any other time. Okay. Now, as I've told you before, the prosecution, under the notion that they have the burden of proof, gets to argue twice, and I only get to argue once. And so I won't be able to answer what he's going to say. I may have already answered some of it in my argument now, but I don't get to go up again. However, there are some things that I can anticipate maybe he'll say. I've already done something. Okay, let's talk about the state of mind at the time of the shooting. We have presented evidence for you that what's happening here is this automatic fight-flight limbic system. This takes over as it does in any kind of emergency situation with anybody. And then the prosecution may say, well, if that's true, then how come so few minutes later they're able to think there's fingerprints on the shells and pick them up, etc. And Dr. Burgess testified about the different stages of this fight-flight automatic impulse system. But I think it's no different than what I talked to you about before with the near miss with the truck. Fear is one of those emotions. When you're instructed about cooling period and heat of passion, you'll see that they talk about emotions that abate and there's a cooling period. Fear is not the kind of emotion that cools on its own. Anger, you can get angry and nothing can intervene at all, and eventually the anger will die down. But when you're fearful and the situation provoking the fear is continuing, okay, the fear doesn't go away until the threat is over. And in this case, the threat is over after the shooting. We've obviously gone past break time here, Judge.
We've gone beyond the hour estimate, too.
No, I didn't say the hour. I said this
morning. 1 hour. About 1 hour to go.
Oh, yesterday.
Yesterday.
Yes, but yesterday I was too tired to know better. When you get tired, you know you get done.
Now that you're not tired, how much longer do you think you have?
I have enough that it pays to give the jurors a break.
How much longer do you think you have?
If I get to have a cigarette or if I don't.
How much longer do you think
I'm
you have?
looking, Your Honor. I'm looking at my notes. I think I have about half an hour.
Okay, 30 minutes.
Yep.
All right, we'll take a recess, ladies and gentlemen, and we'll resume for the final 30 minutes at 10 minutes after the hour.
I wrote down, I see it. I was talking before when we all went off to have our drugs, that the prosecution may argue that Erik could not have been in this state of complete non-thinking panic such that he could not have even intended to kill at the time of the shooting if 3 or 4 minutes later he's able to think in terms of picking up the shells. And I think that that's obviously contrary, that argument is contrary to our own experience, because once the threat is gone, that's when the thoughts start flooding back. And after the shooting is over, that's when they go through what Dr. Burgess described as the numbing period, and the thoughts are able to come back and you're able to do cognitive thinking. Not that they did thinking on any great level or put together a very rational tale afterwards, but nevertheless they were at least able to measure what's happening and figure out what they should do, and that they should say something and that they should come up with a story for the police. And if you recall, it was a very small story. Its parts only had to do with being at a movie theater while the shooting was happening, going to meet someone at Taste of LA, albeit they were late, stopping off home to get false ID, which is the explanation for why they were there, and parking the car in the back before they left the house that night. And that was the whole big elaborate tale, which certainly doesn't sound like something that you would have had to have planned in advance to come up with. And I wanted to focus just briefly on the notion of intent to kill, because intent to kill is the difference between involuntary manslaughter and voluntary manslaughter, and intent to kill is also the express malice component of first or second degree murder. And I have argued to you that there is no direct evidence here, and that is true, that Erik Menendez intended to kill either parent. There is evidence that he assisted his brother in the reloading process, and I submit to you that that too is not evidence of intent to kill. And if you read the aiding and abetting instruction, which is all that he's doing there, because remember, he doesn't even go back. When Lyle goes back into the family room den, Erik does not. Lyle leaves first, he goes in the room, Erik hears a shot, and he sees Lyle coming out of that room, and he has not gone back in. And I think that fact informs whether he intended to kill or not. But I think in actually analyzing what happened here, given the chain of events and the rapidity of action and the state of panic that he was in, you have to assess intent to kill from the moment when they go into the room. And I submit to you, when you're operating on a survival instinct and your only thought is, don't let someone kill me, that is not intent to kill. Now, what I was addressing before we took the break were some of the things the prosecution may argue that I will not have a chance to answer, and so I'm going to try to anticipate them. And one of them is this, and it has to do with the tape of December 11th. I want you to recall, and if you can't recall without hearing testimony about it, then I would ask you this. Most specifically, I can't direct your deliberations, and it would be improper for me to try to do so, but I would ask you this one thing. If you want to use the tape of December 11th to decide any significant issue in this case, I would ask you, besides obviously listening to it, because I think it's important, and listening for Erik, it's important that you hear how he sounds on that tape. The other thing I would ask you to do, if your notes are not adequate, is to have the testimony of Dr. Burgess concerning that tape reread to you. Because one thing you do not know in any detail is what was going on between Erik and Lyle and Dr. Oziel before that tape was turned on. It is obviously turned on in the middle of a conversation. And Dr. Burgess has information that she testified to that it is clear that Erik did not trust Dr. Oziel. It is clear that he thought Dr. Oziel was trying to blackmail him. It is clear that he and Lyle had determined they were not going to tell Dr. Oziel the secrets of the family. They were going to go along with what he wanted, give him what he wanted to the extent that they could. And Erik wasn't even able to do that, really, during the session of December 11th because he was too upset. And so he stayed out of the conversation by and large. And when Dr. Oziel tried to drag him in, all he could talk about was his regret and his remorse and his love for his parents. And you cannot take that tape on face value, because you know that the people participating in it, at least Erik and Lyle, are not intending in that tape to be truthful. But as is characteristic with Erik after the killings, his guilty conscience is such that the truth keeps coming out in hints and suggestions. And of course, Oziel's not interested in that, so there never is any follow-up. But there may be some suggestion by the prosecution that they made this tape. I mean, I think Mr. Kuriyama even made reference to it in his opening. He claimed, and he is in error. And remember, it's been 5 months of testimony. I may be wrong in my recollection of some of the facts that I've talked to you about. And Mr. Kuriyama he certainly thinks I am. That's why I kept objecting. And Mr. Kuriyama may be wrong in his recollection of the facts, but there is a record, and you are ultimately the determiners of what are the facts of the case. You can't apply the law until you first decide what the facts are. But he says that there was testimony from Judalon Smith that somehow Erik and Lyle were supposed to express remorse on this tape, and there's no such testimony. How would she know that anyway? But there's no testimony that Dr. Oziel told her that that was the purpose of making the tape. All we know is that Dr. Oziel suggested in one of the earlier sessions that he, being the genius that he is, could piece together the family constellation. Nothing about remorse. And I submit to you, there's no way Erik Menendez was, at this point, after the way Dr. Oziel had behaved, was going to make a tape for the purpose of it being helpful to him should he get arrested, or for the purpose of staging some remorse. Mr. Kuriyama kept referring to Erik as an actor, and yet you've heard that his behavior and his emotionality is consistent over the entire course of his life. When Erik testified, he was not highly emotional, so I imagine Mr. Kuriyama can't now call him an actor for his testifying. And I think in trying to analyze his testimony, you should keep in mind that no, it is not an actor you saw on a witness stand, but it is the tennis player, the kid who has to go to work. And this was the greatest challenge, if you will, of his life. And he knew he was going to be on the witness stand, and he knows he has to function, and he knows he has to give answers, so he went to work. And he was not highly emotional. And I would frankly preferred that he was. But he did what he could do, given the fear. I mean, and it is. I mean, we're all nervous. I was nervous examining him, but it is terrifying to be up there. And it is terrifying when you have to overcome everything that has happened to you in your life. And I hold it as a great testimonial to the skill of Dr. Vickery, that he took a complete basket case, who clearly could have never even been a witness in his own case, in the condition that he was in 1990, and got him healthy enough that he could do what he had to do in testifying in this case. The prosecution may argue that Erik and Lyle were not truthful about how much clothing was dumped. I'm not operating a complete vacuum here and suspecting what may or may not be said, but I would point out one thing to you, and that is this. Erik testified that he got rid of his pants because he saw these little dots of spray on them. Lyle did not have that on his pants, apparently, because he didn't change them. Now, they may argue, oh, this was such a scene of carnage, there had to be blood everywhere, it had to be all over them, and I will point out to you the one fact that disproves that. You have all the photographs of the house. There is no blood tracks anywhere. There are no drops of blood outside that room. If they had been covered in blood to any extent, there would have been blood evidence outside, took down all the pictures, but outside the area right around the couch, and there is absolutely none. No footprints, no drops, nowhere in the house, nowhere near the guest house, nowhere upstairs in Erik, nowhere. All the blood is right there concentrated. So what he's talking about is these tiny little sprays and nothing else. And so it is not unbelievable or untruthful that one of them could have had that small evidence of blood and nothing greater. One other thing I want you to keep in mind, if Mr. Kuriyama should make the argument that our experts only know what Erik told them, and that's not true.
I want to remind you, too, that they didn't even do a GSR test on their hands to see if there was gun residue. So the investigators could have easily arrested them that night, but they didn't because they failed to do a GSR test for the boys. I mean, they believed the boys. They didn't suspect them at first. So I mean, that's on them because they screwed up their own investigation. They are not suspecting the person who called it in and the people who live in the house with them because, oftentimes it is a family member or someone you know. So they officers failed there.
I think they made it very clear that in forming their opinion, they read everything. They read the statements of all the witnesses who were called, the statements of witnesses who were not called to testify, all of the previous testimony, all of the medical records and the school records, so that when they came out with an opinion about whether Erik was indeed an abused and molested child, it was not based on what he was telling them, but was based on the entire picture of the family that they were able to formulate, that you're able to formulate, based on what other people say. And finally, I want you to remember in evaluating the molestation evidence how very, very secretive this family was. How the relatives who lived closest to them knew nothing about the reality of their family life, knew nothing about the reality of their children. They were told they did fabulously in school. They didn't know differently. Neither child ever betrayed that secret. And the little cousins who stayed in the house over the summers were kept away from their room whenever Jose was alone with them. And so if the argument is made that this molestation could not have gone on in this house, when the cousins are there, I submit to you that the kinds of things that Jose Menendez was doing to Erik don't make a great deal of noise. And the few times that he did assault him in such a way that the child screamed, he made sure there was nobody home to hear it. Mr. Kuriyama said to you, which is entirely proper, that he felt privileged to represent the people of the state of California in this case. He is a district attorney, he is a member of the government, and he likes his job, and he does a very good job of it, and he works hard, and I think his sentiments are completely appropriate. I cannot stand here, though, and tell you that all I feel is privileged for having represented Erik Menendez for 3.5 years. I'm aware of the fact that besides wanting to comment on all of the evidence, I've given you a very long closing argument because I don't want to let go of him. Since Erik became my client in March of 1990, in the condition that Dr. Vickery described to you, it is more than being privileged, and it was more than just a task of representing him to be able to put this trial on. There is no way that you can go back and share the experience of a 19-year-old, which is what he was at that time, without getting more than somewhat professionally involved. And I admit to that. And I admit to an enormous bias in favor of this client. And as you know, his family was always kept distant from him, and were physically and are physically distant from him. And there was that sense in those early days that I was the only person he had. And for 3.5 years, I have definitely felt, shared somewhat by Miss Morrissey, shared, I'm sure, also to some extent by his doctor, Dr. Vickery, that we are responsible for Erik, and we have had him in our hands all this time, and now I have to give him up to you. And the minute I am finished, he is out of my hands, and whatever happens to him depends on what you do. Now, he has not had a great deal of positive experience with adults who have been responsible for his life. I take it as a great compliment that it seems to me, and I think it was something that could be seen throughout this trial, particularly when he testified, that in spite of the type of childhood he has finally learned to trust someone who has control to some degree over his life. And I have to trust you, as Mr. Kuriyama has to trust you, to fulfill your duty as jurors here and to judge him under the law. We have talked about a lot of things in this case, and some of the things that I've talked about in my argument are moral arguments. And there are a lot of things that could be said about the morality of what happened here. But it really is not your job to make a moral decision. For example, issues of holding people accountable on individual responsibility is a social and a moral issue. But if you were to convict Erik Menendez of murder, you wouldn't be teaching him a lesson in individual responsibility. You would be ending his life. This is not the place to teach people lessons that they should have turned out better in spite of what happened to them. What your job is to follow the law as the judge gives it to you. And legal responsibility is a different thing than moral judgment. The law does not expect people to be perfect, and the law does not impose its penalties in order to teach moral lessons. Now, the other thing I want to tell you is this. You are being given a choice of 5 possible verdicts on each count, and I'm not going to give you a lecture on the law. But each decedent is a separate count, and for each decedent you are being given a choice of 5 different verdicts. First-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter, and not guilty. And that is true as to each. And you have to analyze the evidence as to each separately. And you have to make those decisions as to each separately. And this is a very complicated trial. And there is very polarized evidence in this trial. There is no real compromise with the evidence here. Either you accept the defense version of the case in its essential parts, or you accept the prosecution version. And there is no way to compromise this evidence. Either this is a murder, because everything we have told you is not true, and they killed for reasons unproven but completely different than what we say, in which case it is a killing with malice, or it is a killing that resulted from the things that we have told you about, and that it was done under a state of fear. And if that is true, there is no malice, and it can only be manslaughter. Now, my concern is because this is such a polarized case, you may find in your deliberations that you are polarized. The one thing, we all want a verdict. Obviously, we've worked very hard. There's been a lot of time and effort here. But we do not want a verdict if it means that any individual juror sacrifices their own properly held view of the case. And what I mean by that is, it is not proper to compromise. If you believe the case requires a particular verdict and you have deliberated with the other jurors and you have considered all the evidence, you have to stick to your position. Even if it means there will not be a verdict, there will be a hung jury. That is preferable to compromising both sides' right to have the individual opinion of 12 separate jurors. You are 12 individuals. You are not a unit. And although you may all be friends, and maybe that will even survive deliberations, nevertheless, that is your duty as a juror. And one of the reasons that's, apart from the fact that that's a constitutional right to a jury, the other thing, too, is something very tragic has happened in other cases that I'm sure Mr. Kuriyama and I both know about over the course of our experience. And that is, you are being instructed that you must not consider penalty and punishment. And that is true unless we wind up in a second trial here, in a penalty phase. The reason for that, well, there's all sorts of reasons for that, but it's not your job. That's the judge's job. And juries in the past have made the tragic mistake of thinking they knew what the penalties or punishments were for various offenses and thought they were making compromises for that reason. Let me assure you, you do not know. It should never govern your decision to think you know. You should not consider that if you decide the case a certain way, that you will have any influence whatsoever over sentencing, because you won't. That is solely the province of the judge. And I want to remind you of that. And I particularly want
I love this because I hate compromise verdicts. That's not how this is supposed to work. That's not how our judicial system is supposed to work. We just compromise and put someone away for manslaughter. They still get life in prison. Maybe they don't get the death penalty because they didn't get first degree homicide, but now they get manslaughter. They could still go away for life. But you think you're compromising somehow. Or they could get 20 years or whatever it is. You don't know what their sentence could be, what the max penalty could be for that person. So don't vote for that verdict unless you're absolutely sure that that is what your verdict is and it's not a compromise. I love that she put this in here. I wish this was like part of jury instructions everywhere about compromise verdicts that should not exist.
to tell you that your decision is whether it is a killing with malice or without malice. And it is improper to try to compromise by saying, well, I can't decide that issue, so I'll only find second-degree murder. That is a disaster. And I would ask you not to do that. Either you accept what we have proven to you, or you do not. But you do not compromise, because you do neither side any good in doing that. I have had a fantasy since the day I started representing Erik. If people were to ask me after 3.5 years of thinking about him in this case every single day somehow or another, even on vacation, what is it I want out of it? My answer is not necessarily a legal one. There's only one thing I actually could focus on that I wanted. I want to see him walk down a street, not in chains, not in shackles, and not with a deputy sheriff standing next to him. Now, to fulfill my dream and my fantasy, you'd have to come in with a verdict of not guilty. And if you don't feel you can do that, based on the instructions that you're getting, I would ask that you come in with a verdict of involuntary manslaughter, because I believe that's what the evidence shows. And I think all of you will discharge your duties as jurors in this case with great diligence. You have been a remarkable jury, extremely conscientious in being here, in paying attention. It was nice over the last couple of days to see you smile a bit, because we have thought of you as the tough jury as compared to the others who we thought of as the soft jury. But that's all based on appearances. And what I have learned, and what I'm sure Mr. Kuriyama has learned over the years, that nothing can trip you up worse than thinking you know what jurors are thinking based on whether they smile at you or not. There are many war stories. When it's all over, I may share them with you. That is the easiest way to get misled. But certainly if you're standing in front of people for 2.5 days, it's very nice when they're responsive. And I thank you.
All right, thank you. Are you ready to proceed?
Here's a matter
All right. Well, let's do this, ladies and gentlemen. We'll take a recess, and we'll get organized here for the final argument of the prosecution. And there are a lot of people in the audience and a lot of people in contact with improper, and it'd be entirely improper for them to ask. It'd be entirely improper for you to answer. So the best way to deal with any such situation is not to have any contact with anybody in the courthouse whatsoever. You have your
the defendant that was available to us that we could have interviewed to the court. Your Honor, with respect to my argument, there's a couple of questions that I have. I want the guidance of the court. The defense has argued that the defendant that was available to us, that we could have interviewed him for 50 hours just like the defense did. That was never ruled upon, and in fact the defense had made the statement that they would not allow that. So I wanted to get some guidance from the court as to how I can handle that argument.
Well, just so the matter is put in its proper context, the people filed a motion to have the defendant examined. The people cited a recent California Supreme Court case that the people felt supported the position that the examination could be conducted. The defense informally indicated opposition to the motion. the motion was never pursued by the prosecution, and the matter was dropped, as far as this court was concerned, since you never pursued it. But it was the people's position that you had a right to conduct such an examination. That's basically what happened.
That's correct. There was no ruling on it.
There was no ruling because you didn't ask for a ruling.
Well, the defense had indicated that they refused to do that.
Well, that's good, but you never asked for a ruling, you never put it to a test, so that's basically where it sits.
Inasmuch as there was no ruling, and he certainly didn't volunteer to come and be interviewed by our experts, that was inaccurate to that degree. So I just want to let the court know that I will address that in my closing argument.
I'd like to let the court know that the reason, they didn't pursue it, but we thought we gave an informal opposition because we felt that the authority, both the case they cited and other cases, would have permitted it, frankly. And that's why we didn't brief it, because we couldn't find the authority for our position. And they certainly could have asked for a ruling, and I suspect the court would have granted their request. But they chose to proceed without experts. And if Mr. Kuriyama gets up there and starts talking about we asked the court for a ruling, I would object, because I think that's improper argument. The fact of the matter is, based on the authority they cited, had they asked for a ruling, had the court granted it, they could have sent somebody in there to interview him for 50 hours. I think their problem is they didn't have an expert that could help them. And that's why they didn't use it and didn't pursue it.
The inaccuracy is that...
we know their experts sat in this
Okay, let's
court.
not argue about things beyond this limited issue that's before this court. The ultimate concern would be whether or not the prosecution could remark on the right of the defendant to refuse to speak with the psychiatrist or psychologist, regardless of whether there was an order compelling him to do so. It was my impression, quite frankly, that that's really what the prosecution was seeking, just to have the court order and the defendant refuse to cooperate, and then you would use that in some fashion as a issue showing consciousness of guilt or refusal to cooperate, something along those lines. That was my impression, but you never pursued it, so it never came to a head.
And it was our position, which, because it was never pursued, we didn't have to show it, but after we had researched the issue, that if the court had granted it, our client would have cooperated so that we do not get that. So what could be said about it now? He didn't object when I made the statement.
I did object. It was
No,
overruled.
there was an objection.
Well, then-
There was an objection. The court overruled it because I was aware of this history that we've just been discussing.
So in other words, the defense had already indicated that they would not cooperate, and then she has the nerve to argue that he was available. They never volunteered him to
Well,
be
that's not their
interviewed.
job to volunteer.
I know,
It's
but
their
for
job pursue it.
them to argue that is not true.
Well, counsel, as I said, the issue was that you had made a request or filed a motion to have the examination. You never pursued it, so it was never resolved. And we don't know what ultimately would have happened.
That's my
The
point.
bottom line is it's true that we don't know whether or not the defendant would have or would not have cooperated. We'll never know that. That's one of those mysteries that we'll never know the answer to.
We know that the only expression we got concerning whether or not he would cooperate was a negative one.
Well, that's all outside the record.
So was what she argued.
No, she said that you had a right to examine the defendant, and you didn't do it. That was your position. You had a right to examine the defendant. You filed a brief with supporting cases saying you had the right to do it.
I'm not sure if that is exactly how she phrased her argument. I'll have to check that. But notwithstanding that, we did not have the right. We were not given that right by the court because the court did not rule on that.
Well, you didn't ask for a ruling.
That's my point. There was no ruling on it, so how can she say we had the right? We were not
Because you
given that
said
right.
you have the right. You said it. You said it when you filed your brief. You filed a brief and you said you had the right to do this, and this is the legal authority for that. And you wanted the court to issue an order in that regard, and the court didn't do it because you never pursued the matter. It was just dropped. I didn't know why you dropped it. I have no way of knowing when things are not pursued as to why they're not. They just, you file papers and then you forget them. So I don't know, and I have no way of knowing why it is that you didn't pursue the matter, but that's the way it is. Your position was that you had an absolute right to have the defendant examined. So she referred to that in her argument. She's just reflecting what your position is. You're not disputing that you had a right to examine the defendant, are you?
We made that motion, and it was not ruled upon, so I don't know if we had that right.
Well, I thought when you filed the motion, you cited a case, and it was your position that that was a legitimate position, and you believed it was correct.
Well, personally, I didn't file the motion. Mrs. Bazanich did, but that was our position.
Okay.
In fact, that was our position.
Okay, well, then that was your position. You had a right to do it. And you
However,
did that.
just to make a point, I could have filed a brief saying that I had a right to interview him myself, which I don't have. And the fact that I said that I did in a motion doesn't mean that I have that right.
Well,
The fact that
I assume you wouldn't do that because it wouldn't be a correct statement
That's
of law.
correct.
And you filed something that you believe was a correct statement of law.
at the time Mrs. Bazanich did, yes.
Okay.
So-
And you have some reason to believe that that wasn't correct?
Well, I believe she had the authority to ask for the examination. The defense indicated they wouldn't. I don't think that we could have forced him to submit to an
That's
examination.
absolutely true. You couldn't.
So
That's
for
true.
her to say that he was available when they've represented to me that they weren't going to make him available is inaccurate. So I just want to comment on that. That they never. Okay, this is accurate. They never offered him, never volunteered that we be able to interview him. That was never done.
They're not obligated to do that. Why should they do that? What would be their reason to
Well,
volunteer?
they definitely didn't have a reason to do that, and that's why they indicated that they wouldn't do it. But for them to argue to this jury that he was available when he was not available, they didn't make him available. There was no court order allowing us to even try to interview him. So that's the issue.
Okay, I've indicated the posture of the matter as to how it developed and the context in which the court has overruled the objection by the prosecution to that remark. And based on that, it would be improper for you to argue that the defendant could not have been examined, since it was your position that he could have been examined.
I wouldn't argue that he could not have been examined. I would just say that they never volunteered to have him examined.
Again, that's not within the record, one way or the other. So you can't argue that. It's not in the record.
Well, the fact that we had filed a motion was not before the
I've
jury.
already told you what my feelings are. If you wanted to find the specific reference in the argument that was made by Ms. Abramson, I'll be glad to look at it if
Okay.
you want to spend your time doing that. What other matters did you want to
There was
discuss?
one other matter. There was a defense witness who they attempted to put on Dr. Summerfield. They decided, based on my indication that I would cross-examine Dr. Summerfield on Mrs. Menendez's statement that she had information that the defendants were sociopaths and that she feared them and that they lacked a conscience. They decided not to put on Dr. Summerfield, but Mrs. Abramson argued statements apparently made by Dr. Summerfield in her argument that were never in evidence.
Well, they were in evidence. They came in without objection during Dr. Tyler's testimony, in fact. I was very careful, and they came in for all purposes because there was no limiting objection at the time.
Regardless of that, I don't recall you objecting to that in your argument,
Right.
Mr. Kuriyama. So I'm not obviously going to do anything about that now, and it doesn't open the door to your introducing other matters that have not been presented during the course of the trial.
Those are the two matters I wanted to take up.
All right, we'll be in recess until 1 o'clock.
I'd like to get back to the murder case that we started off with back in June and July of this year. What the defense has done is to bring, to my mind, a play by Shakespeare called Macbeth. In the opening scene of Macbeth, there's a witch stirring this pot, this concoction, and she's chanting, "Foul is fair and fair is foul." What did Shakespeare mean by that? That right is wrong and wrong is right, good is bad and bad is good. Things have been turned around in this case. In Macbeth, Lord Macbeth murders King Duncan with a knife. He kills him in his own castle while the king is sleeping. And after the murder, because that's what it was, the king was sleeping and Macbeth went in there and killed him. Macbeth was revisited by recurring nightmares, images of the murder that he had committed. Now, likewise, in this case, the defendant, as Dr. Ozil testified, has been revisited by nightmares of him killing his own parents. But the fact that somebody has nightmares, has a guilty conscience for what he did, does not change a murder into a manslaughter. You'll be told by His Honor that you are not to consider sympathy for the defendant, you're not to consider whether or not he was remorseful. Those are things that don't concern you at this point. Those are things that come in the next phase of the trial that you can consider in determining what you will determine in the next phase. Counsel has indicated that the prosecution has put up photographs that are ugly photographs. The murder is not pretty. Those were photographs that had to do with this case. They were crime scene photographs. Counsel indicated that it was a cheap trick to put on crime scene photographs of the victims in the case. Well, a cheap trick would be to put up pictures of little babies hanging from a bar, for example. If that shows abuse, if that shows that they were being terrorized, then I think a lot of us have done that. In fact, I'm the father of a 6-year-old and a 2-year-old, and I have a daughter.
Did you not hear the testimony where they would just leave him there while he was crying until he started crying and struggling, and they would just let him fall? Did you hear that testimony, Mr. Kuriyama?
Who, when she was 7 months old, I would be doing pull-ups on her bar in between our door. And I grabbed her one day and I put her up on the bar, and she actually hung on to it. So I called my wife over, and my wife took a picture of it. I actually have a picture of my daughter at 7 months. Here's Erik Menendez at 18 months, and that is supposed to show abuse somehow, terrorizing. I'll show you another picture shown by the defense, and that's this photograph. It's a photograph, as Mrs. Abramson indicated, of the cul-de-sac where the defendant was terrorized. I think you recall that there was testimony that the defendant had to go down this death hill, and that he had to go around this cul-de-sac when he was 5 years old. Does that appear to be a hill to you? It looks pretty flat to me, but this is the thing that they testified to as being this horrible hill that just caused this poor child such misery and such fear. You can see Mrs. Abramson in the background there. It's an indication of how the defense can change things, how they can try to mislead you. I'd ask you not to fall for that. There was other photographs shown from among thousands of photographs from this family over all these years that were gathered, taken by the parents. Some of the photographs were shown, others we weren't given access to, and you didn't get.
Objection.
Now, you've seen photographs of Cookie Monsters and ferrets, and you've seen photographs, and I'm going to put these up, photographs of what Mrs. Abramson calls hard evidence of child molestation. And I'm going to put these up in order that they appeared when Mrs. Menendez went to the local store, I suppose, and had them developed.
What's there to do?
This is supposed to show you hard evidence of sexual abuse. When people take photographs, for example, if you put film into your camera, you don't have to take all the pictures in the same day. So these weren't necessarily all taken on the same day, obviously. It will appear from the subject matter that they weren't taken.
Her point, though, was that they were taken on just the family camera, just randomly in between other family events. And likely taken by Ms. Menendez because they were found with in an envelope with her writing.
This is of Erik Menendez's birthday party. And I believe it's the only photograph shown to you of Erik's birthday party. There were witnesses that came in early on that said that these young boys were deprived, they didn't have such birthday parties. The only ones that they show you are the ones that they claim show this alleged abuse.
Who said they didn't have birthday parties? And they were deprived. Nobody said that. What is this proving?
Okay. Now taking a look at these photographs. Here's a photograph of the legs and the lower torso in a bathtub. Now we don't know who took that photograph. The next photograph in this segment is Erik Menendez. Appears to be he's just waking up. There's another photograph that appears to be of the lower part of a bed. And then there's the actual party day. You can see Erik Menendez is wearing this striped shirt. Now this appears to be a different day from the date depicted in the first photograph where you see Lyle Menendez in a t-shirt. And in the party photographs, Lyle Menendez is in a light blue t-shirt with a darker blue collar and sleeves. Now if you look at those photographs, you can see that the fourth photograph really shows nothing. It's blurry, and there's really no subject matter there that one could discern. I'm going to show you fifth, sixth, seventh, eighth, the 10th photograph in this series. And that appears to be from a low vantage point. It appears to only take half of what appears to be Erik Menendez, and then it's the lower body of some adults that are gathered around in the kitchen. It also shows an open dishwasher. The next photograph is what Erik Menendez indicated was him. And the next one is of a little dog. Now, if, as the defendants indicated, if Jose Menendez had taken all these photographs of them naked, where are all of these photographs? They've not shown you any, but they show you this one roll, and they expect you to believe that Jose Menendez took these photographs of the brothers. Would they say that Jose Menendez took this photograph here, the one of the lower torsos of these people, lower bodies, and half of Erik Menendez, and the open dishwasher? What's the more reasonable interpretation of that? They were two kids taking pictures of each other. You could tell by
Why? Why would they take naked pictures of each other? Tell me the reason why they would do that at this young age. That makes absolutely no sense. I don't care if you have blurry pictures and whatever that you think because you think it was taken from one of the boys. They were just messing around with the camera and taking pictures of each other. I don't think so. They're just right in the middle of this whole day, as you can see. Very bizarre.
the vantage point of the photograph. You can tell by the subject matter of the photograph. This, I say, is not hard evidence of anything. If that can prove a child molest, then a lot of people will be convicted of child molestation.
I'm sorry, what? What? If you got naked pictures of your kids, then a lot of people will be convicted of essaying their kids. Well, yeah, if you've got naked pictures of your children and their genitals, there's probably a problem and something going on there. So, yeah, I would say that likely means they're essaying their children.
In fact, suppose someone were to charge Mrs. Abramson with child molestation. And they said, well, that's my word, and what I'm going to do is I'm going to show you a picture that I got from the TV, and it's a picture of Leslie Abramson poking a hole in the penis of this photograph. That shows you that she is a child molester. Now, if that's hard evidence, that's what she would call hard evidence, I suppose.
What?
I think we that have families know that children take photographs. In fact, parents
His arguments are not sensical. Just gonna say
take
that.
photographs of their younger children in baths. I don't think that's unusual.
Not of their
I don't
genitals.
think these photographs really show anything.
You don't take pictures of your kids.
What we've done is to present you with a case against this defendant, charging him with murder. And we haven't brought in any or irrelevant matters such as the defense has. Now, Mrs. Abramson indicated that lawyers play games, that she engaged in game playing in this case. I can assure you that the people of the state of California don't consider this a game. We've been entrusted with a job to bring the murderers of Mr. and Mrs. Menendez to justice. The people put on evidence, 4 weeks of evidence, to establish that the defendant and his brother premeditated and deliberated the murder. The defense, on the other hand, put on about 3.5 months of a lot of witnesses that talked about things that happened years and years ago, put on a lot of irrelevant photographs, and what they've done.
So because it happened years and years and years ago, that means they weren't abused? Get out of here, man. It still happened, whether it happened yesterday or years and years and years and years and years ago. They still grew up in a terrible household with horrific, psychotic people as their parents.
Done is, in playing a game, they've dressed up their defendants in sweaters. They've referred to them as kids, as boys, as children. The defendants are adults, or this defendant is an adult, and his brother's an adult. There are statements made by Mrs. Abramson that I'd like to address. Now, Mrs. Abramson said that Dr. Oziel, there was no evidence that Dr. Oziel was threatened by the defendant, Erik Menendez. If you review Dr. Oziel's testimony, he said that he had been treating Erik Menendez for the burglaries. He knew that Erik Menendez knew where the doctor lived, and Dr. Oziel thought that he and his brother would come to his house. So even though there may not have been a direct verbal threat by Erik Menendez, there was in fact evidence that Dr. Oziel feared both. With respect to the whereabouts of Erik Menendez on July 31st, 1989, there is evidence. If you review the testimony of Erik Menendez, he testified that he remembers that he and his brother were in Tampa, Florida, on that day. Now, the defense says there's nothing to indicate that where the brothers were, whether they were together. You'll recall that Dr. Oziel testified that Erik Menendez had told him that Lyle was not there for the entire movie. If Dr. Oziel were really trying to make up the story, he would have said the brothers were there, they saw the entire 2-part movie. But in fact, Erik Menendez told him that Lyle had come in the middle of the movie. With respect to the BBC movie, you've heard counsel's view on what that shows. Now, what we know is that Dr. Oziel testified that the BBC movie is something that the defendant himself referred to. The defendant referred to the movie as a subject for the brothers to talk about the killing of their own parent. In fact, the father in that movie had been killed. The son in that movie was involved in the killing of the father. At that point, they started to talk about killing their own father. And as the December 11th tape indicates, there was a discussion initially, and the brothers decided that they would, in fact, kill their father. But it would take them longer to decide what to do with Mom. And in fact, they talked about killing their mother, and as was indicated, Erik Menendez had to sleep on it for a couple of days. He wasn't quite sure whether or not he wanted to kill his mother as well. And that's in their own voices. Now, Mrs. Abramson indicated that the only thing Erik Menendez ever did in his life, anything against his parents, was to say, "Shut up." And that there were never any crimes committed. She said that you can understand how a child could kill a parent if there were drugs involved or if there were other crimes involved. And we know what the relationship was with this family, that there was in fact burglaries that had been committed a year earlier. Now, you recall, this is a testimony of Erik Menendez with respect to his father telling him that, or indicating that he was going to disinherit him in September of 1988. There would not have been any discussion about disinheriting if there hadn't been problems that were raised by the sons. When defendant Erik Menendez was asked about the disinheriting, did this have anything to do with the burglaries you committed, have anything to do with your father discussing with you the disinheritance? Erik Menendez responded that being 70th in tennis was more important. And he indicated that he was sure that his father was upset with him about the burglary. There's no question about that, he said. But I don't think that's the main reason. That may have been the straw that broke the camel's back. Now, what that indicates is that there had been problems. There had been problems by the sons, that they were causing problems for the parents. This is not a case where, as counsel will isolate and say, well, it was just because he said, "Shut up," one day. And that's the only thing the people can turn to. What the people can turn to is the fact that there had been these prior crimes that had caused the parents a lot of grief, and there was discussion about disinheritance. Now, the defense has argued that the defendant, Erik Menendez, in telling Dr. Oziel on October 31st that he killed his parents, he entrusted Dr. Oziel with that information, but he didn't trust him with any other information. Never said, "I was acting in self-defense," or "I honestly believed that they were going to kill me right at that minute." Never made any of those comments. Yet, in his testimony, He states on September 17th, when Detective Zoller went to talk to him in Cranberry, New Jersey, the defendant says that Dr. Oziel is a very good friend of mine and that he spent a lot of time with us after the killings. And so when I asked Erik Menendez, so Dr. Oziel, as of September 17th, was a good friend of yours, wasn't he? Erik Menendez responded, I viewed him as a friend of mine. There's no question about that. Now, what the defense will have you believe, and the fatal flaw in their argument, is this. The defense has spent years on trying to dirty up Dr. Oziel. They have gotten former girlfriends. They have gone to
They didn't need to dirty up Dr. Oziel. He was already dirty. You brought him in that way. They just revealed it in court.
other measures to try to dirty him up. Now, there's no showing that Erik Menendez knew anything about this, anything about the background of Dr. Oziel during that period of time. And in fact, he's saying just the opposite. He's saying, I trust him. He's a friend of mine. Yet, in this case, they're saying to you that for some reason that we don't know, that Erik Menendez said, well, I didn't trust him. Trusted him enough to tell him that I killed my parents, but I didn't trust him to tell him that I thought I was acting in honest self-defense. Counsel indicated or tried to argue that the BBC movie was somehow made up by Dr. Oziel. We know that the defendant himself had a friend named Brian Eslamania, who happened to be the son of the person killed in the movie, BBC movie. Now, this person, this Brian Eslamania, was going to be one of the four that Erik Menendez spoke about, his four trusted friends, including Craig Signorelli, who would make up to $1 to $2 million in this corporation. Erik Menendez had plans to form something just like the BBC. Now, how would Dr. Oziel know about Erik Menendez's plans? How would he know who his friends were? How would he know that he had a friend that had a father who was killed by Billionaire Boys Club members? In fact, Erik Menendez talks about it enthusiastically, that he's going to form this group and that they would all have a Rolex watch. The defendant will have you believe that he wasn't interested in any kind of gain from his crimes, when we know that he was with his brother. He'll try to put it off on his brother now, but he was with his brother when they bought the Rolex watches. He was with them when they bought the money clips. Lyle Menendez didn't need 2 gold money clips. One of those was for Erik Menendez. Counsel indicated that Erik Menendez is the good guy. Lyle was the worst of the two, I suppose, she would argue. And she said that when Mr. Heffernan, the coach, testified what Kitty would do, would say, you have to do this. She said it was only Lyle who would be mad at Kitty. And it wasn't Erik that did that, but as you can see from the testimony of Mark Heffernan, he said the boys would be mad, not just Lyle. So here's a brother, Lyle, who supposedly was trying to protect Erik, and now the defense is claiming, well, he's the one that shot mom and dad in the head. You know, he's the one that would yell at mom. So they're trying to lessen the culpability of Erik Menendez, but we'll go into some instructions about that later on. There has been, in this case, the subject of homosexuality has been brought up by the defense. I'm going to discuss this evidence.
This should not even come in. There's no freaking evidence that anyone here is a homosexual, except maybe Jose might be bi. I don't know. Maybe he's a homosexual, and that's why Kitty was so upset. I don't know. But there's no proof that any of the boys are homosexual, and that homosexuality has nothing, absolutely nothing, to do with being a victim of SA. Nothing.
In the case as it relates to the defendant's homosexuality issues. And what I'd like to do is preface that homosexuality is a personal choice, and gender preference issues are personal ones. And one can certainly understand the reluctance to come out. But because of the defense and because of what they've tendered in this case, I think it's relevant, and I think that I have to address it. As we know, the defense psychiatrist, Dr. Vickery, said that the defendant feared that the issue of his homosexuality would come out in the trial.
Objection.
Let's review the evidence according to...
Was there an answer from the judge? That's not even, that did not come out in trial. So, yeah, objection, that states facts, not in evidence.
what the defendant says. Number one, as a young teenager, he and his buddies spoke about how to make semen taste better. The defendant learned that cinnamon would do just that. Now, I don't know if you, when you were a young teenager and you talked with your friends, whether that subject ever came up. I think it's not a usual subject matter. So we don't know who...
Yeah, it's one of those topics that come up on the school playground one day because kids are bored and they heard it somewhere else, and that's what they get a bunch of people around and they tell them that, and then they go, "What?" It's really not that difficult to imagine that this topic came up with kids and Eric overheard something at school and decided to apply that at home because of what was happening to him.
Who the friends were or the nature of the relationship, but we know that that's what he testified to. Number two, we do know that Mrs. Menendez was taping the defendant's calls, and this is probably at least back to September of 1988, so sometime at least a little after the burglaries that the defendant did, burglary and grand theft. The mother was monitoring what her son was up to. And as the defendant testified, he actually found this little device, and he found out that his mother had been taping his calls. And so he listened to those tapes, and he did find that he actually listened to the tapes. They were of his conversations, and he destroyed those tapes. So we don't know what the subject matter of those tapes. In the words of Mrs. Abramson in her opening statement, he genuinely believed that his mother had supernatural powers because she knew all the things that he was purposefully concealing from her. She never stated what it was that he was purposely concealing from the parents. The defendant also testified that Mrs. Menendez read his diary. We know that the defendant's mother confronted him about being gay and asked him to get a girlfriend with giving him a 6-month deadline. Number four, according to the defendant, his mom didn't think much about a person being gay, and that Mr. Menendez called him a faggot and hated gays. Now we know that Mrs. Menendez told the defendant that she's not stupid, she knows. Defendant Erik Menendez never did clarify what it was that she knows, but she's told him at one point she knows. What do you think, I am stupid? I know. We know that the defendant found out after he murdered his parents, as I've indicated, that his mother was taping his calls and actually listened to the tape, and he actually listened to the tapes going back to the fall of 1988. We know that he destroyed those tapes, and so those tapes are still secret. The defense in this case has made a lot of references to secrecy and secrets. We know that the defendant, although he bought new furniture for his Marina City Club apartment, and he brought his bed with him as well, this bed that his father supposedly sodomized him on and molested him on. It's like the only piece of furniture that he took with him to the Marina City Club apartment. He took that with him. We know that the defendant claimed that his father made him get into a certain position, according to the defendant, on the bed. And he said that the bed had this edge on it that was kind of rough on his knees. And he said that it was uncomfortable. And after the killings, this is November 30th, you got some evidence in this case about a receipt for these bed pads that he claimed he needed on November 30th, 1989, 3 months after the murders. With his father no longer around, no longer there to require him to place his knees on the bed in this awkward position, he purchases bumper pads for his bed and for these edges of the bed. And you wonder, why would he do that? His father's dead, and no one's making him do what he says his father made him do. Now, according to the
Maybe because it was triggering and he couldn't stand looking at them and he hated being in their room because of the memories that he had of his father. Maybe that's just why. Maybe he couldn't stand looking at those because of how much pain they caused him. Maybe he ordered these things long before his parents' homicides because, he just, and it just took that long to get there because, he didn't plan on taking their lives. He had wanted to put the bumpers there to protect his knees. Maybe that's it. Like, there's a million other reasons besides he's a homosexual. I don't know. I don't know where he's going, but okay. He's just covering those because why? His dad's gone, and what does that have to do with him being a homosexual that he's covering those edges that are a daily reminder he has to look at about the torture and abuse that he suffered by his father? Why? Why should he have to keep looking at that?
The defendant's testimony at the time of his arrest in March of 1990, he had his cousin Andy Cano destroy or conceal evidence from his Marina City Club apartment. Andy Cano, when he testified, he denied knowing anything about this request that Erik had made from him. Erik testified that his cousin Andy Cano had destroyed this evidence. We don't know what that evidence was, but Erik Menendez said that he had something at his apartment that he asked his cousin Andy Cano to destroy or conceal. Finally, with respect to that issue, when asked at page 16,089, what did you think when your father, who's having sex with you, is talking about being gay? And Erik Menendez responds, in part, I didn't think that what Dad and I was doing was a gay thing. Yet, his expert comes in and says he had a fear of having his homosexuality apparently come out. Indeed, if the defendant were engaged in...
That never happened. That never, like, I don't know what he's talking about, where he had a fear that his homosexuality was going to come out. He's not homosexual. He's been married to a woman for years. He's not homosexual.
Consensual sex, homosexual activity with other men, that would account for his being able to describe what he described for you, his sexual encounters with his father. Now this brings us to the discussion of the defendant's claims then of sexual abuse. Because Mrs. Abramson asked, what's the reason for not questioning the defendant on the allegations? Well, number one, it would have been fruitless. We know that the defendant is an accomplished liar. As Mrs. Abramson stated yesterday in her argument, you don't get a person to say they lied on the stand, and you weren't going to get that out of Mr. Menendez. We know that he lied about the Big Five, and he was very detailed about the Big Five. He never said, oh, I was wrong. He tried to explain it away. He tried to say, well, I was there. And then at another point, he said, well, you're the one that said it. And then he tried to say, well, maybe the clerk was the one that was wrong. So he never said, oh, I was wrong. I wasn't there. He never said that. We also know that he lied about the BBC. He tried to tell you that the BBC had to do with the British Broadcasting Company. We know that we had to bring in the transcript of his testimony, or actually his interview or conversation with Craig Signorelli on November 29th. We brought that in and confronted him with that. So at that point, he had to admit that he knew the BBC was the Billionaire Boys Club. But if you don't have a transcript, if you don't have a tape, he's not going to admit to anything. So we don't have Jose Menendez here, obviously. The defendant knew that he could say whatever he wanted to. Jose Menendez was not going to walk through those doors and come up here and tell you that his son was lying about these allegations. He killed the only witness that could contest it. Now, if Mr. Menendez were molesting the defendant, would he have allowed his nephews and nieces year after year after year live with the family for months at a time, let friends of the defendants live over for months at a time? If this family was so secretive, why would they have allowed all these people to come into their houses and live with them? Now, this tack placement, remember when Mrs. Abramson was up here putting those tacks up in the photograph, the tack placement in the legs and penis? This defendant was a swimmer and a tennis player. You wear shorts when you do those activities. There weren't any witnesses that came in here and said they saw these horrible marks on his thighs. We have voluminous...
How big do you think a scar is going to be from a thumbtack being poked into your leg? Do it to yourself and see how bad your injuries are. Try it out, Mr. Kuriyama.
medical records, there's no evidence that anybody saw any of these marks in any of these examinations of this defendant. Dr. Carrie English testified that there was no anal scarring and indeed no physical evidence of sexual molestation on the body of either this defendant.
Anal scarring is very, very rare, and physical signs of sexual molestation are very rare, especially with men and children. But we do have some corroborating evidence where Erik had a injury to the back of his throat, which could have easily been from Jose SAing him. He often had to give his father oral sex. So it's not unheard of. It's not out of, the realm of possibility that he injured his throat from Jose during one of their sessions. But this guy claims it never happened. Okay.
Defendant or the other defendant. Now, if the defendant were being molested, he would have surely jumped on the chance to go to school away from home. Yet we have Ed Fenno, who stayed with the family from about September 1988 till about February 1989. And Ed Fenno was there when Erik Menendez got his acceptance letter to Berkeley. And Mr. and Mrs. Menendez were very happy that he got into Berkeley. And what does Erik Menendez do? Well, he pulls Ed Fenno aside and says, well, I want to go to UCLA. You didn't want to go to Berkeley. Now, if you were being molested, you'd want to get as far away as you could from who was...
What? He still wanted to go away to school. He wanted to go to UCLA but potentially have that college experience. I mean, they had money. He could have lived on campus. They were getting him a dorm anyways. Whether he went to Berkeley, UCLA, or Princeton with his brother, it didn't matter. The fact of the matter was, Jose told him he was going to have to come home and stay. But Erik thought he was going to get to go away and, do the college experience. But Jose had other plans for him.
molesting him, it would seem. But he didn't want to do that. He said, well, no, I know my parents are going to be upset about it, that I don't go to Berkeley, but I'd rather go to UCLA, he says. We know further that this claim of abuse came out only after the defendant was in jail for 6 months, and before that he had been on the streets, scot-free for 7 months. Now this story emerged only after a year, over a year after the killings. Now, just as you cannot prove a negative, just as the defendants claim that the mafia did it, we can't go to every mafia member in the world and say, hey, did you commit this killing? What you do is you find who the killer was, and you prove it that way. Likewise, as to this killing in this case, the defendants have shown no honest belief that the parents were going to kill them. We showed premeditation and deliberation. We showed planning, and the decision to kill was made.
The boys didn't have to show that the parents were actually going to hurt them. All the boys needed to show, or all the defendants needed to show, was that they were fearful. It didn't need to be a reasonable fear to you, but because they were in a state of fear, it was reasonable to them at the time, especially in the fight or flight stage and with all of the prior knowledge that they had of their parents and the threats that they've received before from their parents. God, this is infuriating to listen to. It's like they have no facts of the case correct.
There was no honest belief that they were going to be killed that night. So what we have is plans. There's a plan 1, a plan 2, a plan 3. The defense plan 1 was to say that he and his brother were at the movies, and then they went to the Taste of LA and happened to come in on their parents. They found their parents murdered brutally, and they're the ones that called 911. They remained on the street for about 7 months. They're enjoying new cars, new Rolex watches, new money clips, new furniture, new condo in Marina City Club. The defendant buys a new pool table for himself, and he got into concert promotion and placed an offer of $1.1 million on the house in Marina Del Rey. He also enjoyed trips to Cancun and skiing trips. However, in March of 1990, Jude Lund Smith, as you've heard testimony, came forward with information that led to the defendant's arrest. Now, the defendant was in jail for some 6 months after going through hearings in Santa Monica Superior Court regarding the tapes issue. And over a year after the murders, the defense moved over to Plan 2. What is Plan 2? Plan 2 is, well, our parents abused us. We know from witness Carlos Baralt and Terry Baralt that the defense team had indicated that the defendants would claim abuse at that time. Thank you. Now, at that time,
No, as I've indicated, ladies and gentlemen, you are the judges of the evidence, and whether the lawyers recall it the same way you do or not, ultimately you will tell us what the evidence is, and there might be some differences in recollections as to any particular piece of evidence, but ultimately you will decide what the evidence is. You may proceed.
That was not the basis of
That's still the court's ruling. You may proceed.
thank you, Your Honor. Again, Carlos Baralt testified that he was told of this claim of abuse, but at that time he wasn't told that they were acting in honest self-defense. They honestly believed that their parents were going to kill them. He was told simply that they were going to claim abuse. Now, however, having been abused as a child does not justify murder. And child abuse, if it occurred, is not a capital crime. And in this country, in any event, you have a right to have a trial.
Child abuse should be a capital crime. Why isn't it? Let's talk about that for a second. Why are people who take the lives of their abuser, why are they going to prison for life when their entire life is ruined because of that abuser? They have a life sentence of having to deal with that trauma and anxiety and depression and never being able to trust people and all the things that come with it. That's a lifetime of being messed up, like being emotionally, psychologically challenged because that person decided to do what they did to you when you were a kid. It should be a capital crime. You should not, we're putting child abusers away if they even get locked up. They go away for a couple years and then they get released into society to go do it again. And if they are honest and they register as a sex offender, okay, fine, but they're still out and about and can still do things that can damage children forever. Not just, it damages your entire life, not just as a child, but throughout your entire adult life, it messes with you. So it should be a capital crime. Let's talk about that. Let's be a little harsher on our punishments with child abusers and people who are sexually violent to their partners. Let's talk about that. Those are things that I think need much higher prison sentences.
And the defendant cannot make himself to be the accuser, the prosecutor, the judge, the jury, and the executioner. Because this was not a defense, this is not a defense to murder, they go to Plan 3. And what's Plan 3? Plan 3 is if you get a jury to believe that you honestly believed at the time that you were going to be killed yourself, maybe that'll get you down to manslaughter. And they're now in Plan 3. Question is whether they honestly believed that they were in imminent peril. Now, they would have to show that they believed honestly, that the parents were about to kill them, or that, as they've indicated, the father was about to sodomize Erik Menendez on August 20th, 1989, when he and his brother bursted into the family room, with their pump shotguns blazing. They're going to show that they honestly believe their parents were going to kill them. These are the shotguns that they had purchased 2 days earlier, having used false identification and a false address in a cash purchase, knowing that Lyle Menendez made his purchases on a credit card. They went all the way to San Diego. They had an alibi that night established with Perry Berman about going to the movies that night, and a plan to connect up with Mr. Berman later that day. This surprise attack, having occurred, as the defendants indicate, on the December 11th tape, occurred after they had already decided that they were going to kill their parents. This was a premeditated killing. And so when Erik Menendez testifies that he goes out to the car, and he goes out and gets the ammunition and passes it to his brother, there didn't have to be any other conversation. They knew, they intended when they entered that room to kill them both. They weren't going to leave survivors. In fact, even after they had shot all their ammunition from their shotguns, the mother was still alive. She was still moaning, and she was still trying to crawl. And they reloaded, and they shot her. Actually, Lyle shot her in the face.
No evidence she was actually still alive.
Now, counsel argued that the defendant, Lyle Menendez, didn't have to admit that he reloaded. But when you have this number of shots in this case, and you have the evidence, and counsel indicated that there was no evidence whatsoever that indicated that they reloaded. Well, Dr. Oziel testified that they told him that they reloaded because she was moaning and trying to crawl away. So in fact, there was evidence.
No, there wasn't evidence. He admitted to it. That's the only evidence you have. He admitted to the fact that they went and reloaded. There was no evidence to that. There's no way of telling which, which injuries came first, which came second. There's no way of telling. So her point was the only way that investigators knew that there was a reload was because the boys admitted it.
The tape of December 11th is in their own voices, and although they knew that they were being taped, although they knew that they were supposed to try to show some remorse, Erik Menendez, I believe, shows that he's brighter than his brother. His brother didn't show any remorse in that tape at all, as you can hear. Yet Erik Menendez shows remorse. Now, there's a witness, a defense witness in this case, named Ed Fenno. And Ed Fenno testified Ed Fenno testified that he's the one that lived there from September of 1988 to about February of 1989 with the family. And he was asked in cross-examination about the interaction between the defendants and their parents. And Mrs. Bazanich asked Ed Fenno, and this exchange occurred. During the period of time that you observed the interaction between the defendants and their parents, did you ever see the defendants lie to their parents? And the answer was yes. On how many occasions would you say you saw them lying to their parents? And the answer was more than a couple. Was it something that was somewhat common? The answer was somewhat common, yes. The question was, and what kinds of things, first of all, did they both do it or just one of them? Both of them. And what kinds of things did they lie to their parents about? Stuff when they got in, if they did something wrong, Lyle, there was one time where Lyle, he was driving his dad's Cadillac and he kind of sideswiped the mirror, got knocked off, and he didn't want to tell him that. That is what happened. So I don't remember what the story was, but he told him some other kind of story about how that happened. And the question then was, when he told him the other story, was it a detailed story or was it just sort of vague, if you recall? And Mr. Fenno said, I think it was reasonably detailed. The question then was, did you ever see Erik Menendez lie to his parents? The answer was yes. And what kind of occasion did you see him lie? The same kind of situation where they'd done something wrong and didn't take responsibility for what was wrong. And they didn't take responsibility? They didn't want to take responsibility.
What teenage kid hasn't lied to their parents to get out of trouble? Raise your hand. Crickets, right? Okay.
Responsibility. They would lie, and they would lie in detail because they did something wrong and they didn't want to take responsibility. So that's not something that was just something that occurred at the spur of the moment here. That's something that was ongoing. You remember the testimony of the same Ed Fenno about the Berkeley information that came in. Erik Menendez got this Berkeley acceptance. His parents were very happy about it. And Erik, as he indicated in this exchange, Erik stated that he didn't want to go there. He wanted to go to UCLA. So this has to do with this claim of child molestation. He didn't want to leave home, which contradicts someone that would, as he indicated, he wanted to leave home. But when given
That's not what he said.
the opportunity, and when his father and mother are saying it's a great school, he doesn't want to go there. would lie regularly when he did something wrong. He would give detailed lies to avoid responsibility for wrongdoing. We know that the defendant lied to the police who arrived at the scene on August 20th, 1989. We know that he lied to Sergeant Edmonds on the early morning of August 21st, 1989. We know that he lied to Detective Zoller on September 17th, 1989. We know that he lied to family members. We know that he lied to newspaper reporters. We know that he lied to his Uncle Brian. And we know that he lied at his parents' memorial service.
Okay, the boys are liars. They've lied. That doesn't make everything that they say a lie. And most of their lies were to protect the family and the family secret.
The defendant has lied throughout, and you know that he's lied in this case as well. He lied about the Big Five, he lied about the Billionaire Boys Club. And what we've presented is evidence of premeditation and deliberation, that the murder was committed with premeditation and deliberation. You know, a person would have to be pretty gullible without common sense to believe that this defendant honestly believed that he feared his parents under the circumstances presented in this case. I don't think that you lack common sense.
I believe they did fear. They've been threatened how many times about if they said something, he would end their lives. I actually do think that they feared imminent harm or death. Whether that was going to happen or not isn't for us or the jury to decide. It is what the boys believed, and I believe they were fearful based on, like I said, all the knowledge that they had of this scary psychopath father of theirs. They've grown up in this house. They know what he's like. There's no reason to believe that Jose would go easily along with this. So they were fearful.
The defense has brought in many experts. They brought in experts to talk about what the defendants were feeling at certain times. They brought Dr. Tyler in, Dr. Burgess, and then they brought in Dr. Vickery. Now, Dr. Vickery, you'll recall, testified that the defendant, for the first time in jail, this is in the fall of 1990, for the first time he could actually sleep because he didn't have his father there, that he felt safe. We know that he was on the street for 7 months. Was he not sleeping then, or was he sleeping okay then? But once he gets into jail, he's trying to tell this doctor, well, this is the first time I can sleep. Well, he had killed his father already, and he had been on the street and in his condominium in Marina City Club for 7 months before he was ever arrested. So that statement that, oh, this is the first time I can fall asleep, we know that's a lie.
How do we know that's a lie? He was probably scared he was going to get caught or riddled with guilt, which he was, and anxiety because of that. He couldn't sleep. When his father was alive, he couldn't sleep because he was fearful that his father was going to come into his room at night. Whether he locked the door or not, it didn't matter. Once his father was dead, he was fearful of getting caught, of the fact that he did it. He was guilty. He felt a tremendous amount of guilt. He loved his parents. He was struggling with the fact that he loved them, but he had to do this thing because they were hurting him. So he was struggling with this. And that's why originally he went to Dr. Oziel, because he was ready to take his own life because of how much stress this all has caused him.
I'll go over a few things that counsel indicated. She told you that there was no evidence in this case that Mr. and Mrs. Menendez had to pay back $60,000 to $70,000 to the victims in these burglaries. Mrs. Abramson stated that it was $12,000, and you can go through this transcript and see if you could ever find any testimony to that effect. You will find, however, at page 20,038, testimony given by Ed Fenno. And what that testimony is right here. The testimony that goes like this. I remember that he told me his dad had to pay for all the stuff, they basically had to take everything back, and everything that wasn't taken back, he had to pay for it. Question, did he tell you how much money his father had to pay back? Something like $60,000 to $70,000, I thought I heard. Did Erik Menendez ever indicate to you whether or not his father was happy with him for having participated in this? I think he was unhappy, according to Ed Fenno. Mrs. Abramson said that there was nothing in this transcript that said that they had to pay back this money, but you see it right before your eyes. There was testimony by Ed Fenno to that effect. Mrs. Abramson also said that Carlos Peralta never said Jose loved his sons or wanted the best for his sons. I'm just going to give you a couple of these just to show you that, in fact, there was the testimony in this case. This is Carlos Peralta's testimony. Did you ever see any signs that Jose Menendez loved his sons? Absolutely. What signs were those, sir? His life pretty much was devoted to trying to educate their kids in a fashion that they thought was best possible. And I take it that you found some fault with some of these educational processes that Mr. Menendez engaged in. Yes, I did. But did it appear to you that he wanted the best for his sons? Absolutely. So although you could disagree with what control he had over his sons, as Mr. Peralta said, they were his sons, and even though that may not have been what he wanted for his own children, who is he to criticize? So there was, in fact, this love for his sons. I know the defense has tried to say that there was no love there, it was just control, but I think there's been a character assassination of the parents in this case, which was undeserved.
Leslie predicted you were going to say that. This is not a character assassination. This is the cause. This is the root cause as to why these crimes happened, and you're not listening because you're too blind with rage or whatever, because you find the thought of murder more offensive than parents who touch their children when they're young in appropriate ways. In inappropriate ways, I mean. To me that's more offensive. I'm sorry. It just really is.
And well overdone. Now, with respect to Grant Walker, Mrs. Abramson really talked about Grant Walker and said that he just wanted his 10 minutes in the limelight, that he came in here and he lied. We know that he was in fact there. He worked on their heater. We know because we've talked to Mr. Bartek, who said that he sent him there. So there's no question that he was there, that he wasn't just someone that came out of the woodwork, and that he indicated that he even told his wife that he was a little bit upset at how these brothers were reacting to their parents. And he testified that he recalled that vividly because of what had happened that day. Oh, about the post-crime route. We had testimony about the post-crime travels of the defendants. And first, remember that Lyle Menendez testified, and he tried to say that they waited around at the house, and so to try to show that they really didn't premeditate anything, they were waiting because they thought the police would come, so they were waiting around. And he put too much time on it, apparently, because the week later, in fact, Mrs. Bazanich was cross-examining Lyle Menendez and basically said, well, you could have done all that in that time frame. And what do you expect Erik Menendez to do when he comes to testify a week later? Is he going to use the same times? It just so happens that his times come right about the time limitations. He says, well, no, it wasn't 5 to 10 minutes, more like a couple minutes here. And no, it wasn't 10 minutes that we took to go to the theaters. It was a couple minutes. So he brought all his times down, but you expected him to do that. And the defense will say, well, why don't we go with Erik Menendez's times? Well, the defense had a week to work on that. It's not like you expected him to come in with the same times. You know that both brothers testified in this case, and the credibility of both of them is an issue for you. When counsel refers to the 1211 tape and she says, well, there's a little word here, a little word there, and they were looking for cues, the defendants are not talking about little words here and there by their parents. They're talking about their own discussions. It didn't take a whole lot of discussion because they had discussed and they had decided preliminarily that they were going to kill their parents. So what they're referring to is discussion among themselves. We know from Lyle Menendez's testimony that during the 3.5 years that he's been in custody, he's been much of that time housed next to his brother. We know that the defendant, Erik Menendez, had phone privileges. He could certainly write to people, to witnesses. It's not like he's completely isolated from everybody. In fact, Dr. Vickery testified that when he would go to jail, he'd see Erik Menendez on the phone a lot. Now, there's a lot of blame put on Dr. Oziel, and one part of that is the defense claims that Dr. Oziel is the one that put it in the defendant's heads that they were being controlled. But when you saw that chart come up here, and Mrs. Abramson looked at the chart, a lot of those people said that he was controlling. But yet, it's only Dr. Oziel who put it in their heads that they were being controlled. We also know that there's talk about suicide, and the defense claims that it was Dr. Oziel.
Dr. Oziel was putting thoughts into the boys' heads. He was suggesting certain things. He was suggesting reasons why. Whether it's true or not, you could tell from the tape that Oziel suggests them, not the boys, not the brothers.
Oziel, who put that in the defendant's heads to say, well, it makes the murders a little bit more palatable because the mother was suicidal. Well, if you take a look at the transcript of the September 17th, 1989 tape, and you listen to that tape, the defendant himself states, and he tells the police this is his idea, not Dr. Oziel's idea. My mom was really nervous lately. She did write a note, which we found before. It indicated that she might be expected to die. Basically saying, that we love you a lot, and there's a letter somewhere that if I die. So that was something that came from within Erik Menendez's brain. That's something that he...
But that's true. That's a fact. That happened. He found a suicide letter from his mother. This video, there's so many words in here that are shadow banned from YouTube. I'm sorry. I just knew there was too much to say without trying to change my tone. So apologies to YouTube. I'm not going to monetize this. But anyways, so she wrote a suicide letter and Erik found it, called his brother Lyle at Princeton, and they talked about it. He was freaking out, obviously. I think the mother purposely left it out so someone could find it for attention. I don't know if she meant for her children to find it, but she definitely wanted attention for that. No.
He told to Dr. Oziel. Yet the defense will say, no, it was Dr. Oziel's idea. That was his idea. Counsel said that witnesses make a lot of money, expert witnesses make a lot of money. The prosecution makes a fortune, she said. That probably got a lot of laughs for prosecutors and attorney generals across the state that we're government attorneys. We're not attorneys who live in Hancock Park, as Mrs. Abramson told you. She lives in Hancock Park and drives
They made a
it.
fortune, said he was paid.
Counsel, you have to argue again. You only had your chance. Let's let the prosecution argue this time.
It's you heard how the estate went, and Brian Anderson was the one who represented the estate, at least to the extent of his mother, and that they agreed to the payment from the victim's estate to pay for the defense. Mrs. Abramson said that the maid was in this soundproof room and she couldn't hear anything. And when the maid came in to testify, Flor Surya, she said that she could hear the TV next door. She could hear the TV in the TV room from her room. But they want to say, no, you couldn't hear it. Well, you had the person who lived there, who slept there, who said she heard it. You heard Ms. Abramson say that Lyle Menendez testified that he heard the yelling, the screaming, the commotion coming from the stairs near his house, the guest house. But if you look at Lyle Menendez's testimony, he says he hears this horrible yelling and screaming from the main house. Take a look at that testimony. It's from the main house, he says. In fact, testimony goes...
Yeah, the screaming's coming from the main house, but he was in the other house, in the guest house.
And you were inside the guest house when you heard the screaming? I was somewhere in the guest house when I heard the screaming. Could you tell from which direction the screaming was coming? Yes. Where? It was coming from the main house. But counsel told you that Lyle Menendez didn't testify to that. But you could listen to his testimony, or actually, I don't know if the court really wants to read it all back, but it's available. Counsel also had a lot of bad things, derogatory things to say about Jamie Pisarcik. That she committed a theft. Here's a woman who works just about every day during the period of time, just before summer of 1989. She's working as a waitress. Lyle Menendez gives her permission to use the calling card of the business that Jose Menendez was involved in. She calls that a theft, even though Jamie Pisarcik has permission to use it. But when she refers to the residential burglary and the grand theft of this defendant, that's juvenile acting out. Here's a lady that's working every day at this restaurant, and she's guilty of theft, ladies and gentlemen, because she's using this credit card, this calling card, and it's after she had broken up with Lyle Menendez. She's a horrible person. We know that her testimony, and it's clear that she had testified. She wasn't sure that what time it was exactly. In fact, she testified during the trial that I'm not sure to be exact when it was that this conversation with Erik Menendez took place. And she said that she remembered, because she couldn't remember the precise time, she was asked whether she saw Lyle and Erik and the whole family there. And she said on cross-examination, Miss Lansing, as a matter of fact, Lyle and I did go to a play in Westwood. I do recall that. What did you see? We saw Hurly Burly. And where was that? At the Westwood Playhouse. Who went with you? Anybody? Just Lyle and I. So she's telling you, okay, I'm off on the date, but I know that I saw Hurly Burly during this period of time. Hurly Burly, through the stipulation we know, played from November until January of 1989, November of 1988 to January of 1989. We know that Flor Surya, the maid, testified that she had seen Jamie there at the house, and that would be the time frame, consistent with that time frame. And also we have Ed Fennell, who said that Lyle Menendez had visitors in the guest house. Jamie Pisarcik was one, I believe Cole Kruger was the other. And we know that Ed Fennell was at the Beverly Hills house from October of 1988 until about February of 1989. So that's the time frame. So yeah, she was wrong about the spring of 1989, but she did recall this. And actually, it's lucky that the defense cross-examined her on that, and she was able to remember that particular detail of it. with regard to Craig Signorelli. Now, the defense says that Craig Signorelli really goes to the special circumstance of lying in wait. That since Craig Signorelli saw or took a confession from the defendant on September 1st, where the defendant indicated that he was at the door with his brother and he looked inside and saw his mother and father on the couch, that shows there's a lying in wait. And she says that he's a screenplay writer. Well, we know that he wrote screenplays with this defendant. We know this defendant is a screenplay writer. She calls Mr. Signorelli a troubled youth. And we know that Craig Signorelli talked about the Haymans, not by name, but by saying that the computer man was there with his pregnant wife on March 7th of 1990. The Haymans weren't even located until May 7th, 1990. With regard to that special circumstance, there were some questions asked of the defendant, Erik Menendez, in his direct examination. Did you ever tell Oziel in describing how the shooting occurred that you surprised your parents? He says, I doubt it. I don't know. Mrs. Abramson says, you doubt it? And Erik Menendez says, I may have. And Mrs. Abramson says, well, why would you have said that? I said we ran in on him, so I don't know. Dr. Oziel remembers that he said that he surprised his parents, that they planned this all out, and they actually surprised their parents. And the crime scene photographs are consistent with that. Do you think that those parents had any time to do anything but to get up and scream, maybe, as this defendant and his brother entered into that room and started blasting them? I think the crime scene evidence showing Mr. Menendez seated with his legs crossed over, his head back, I think indicates that they were surprised. They didn't know what hit him. And in fact,
That's just how his body fell on the couch because he was standing up when it happened. Because there's absolutely no way a couple of the injuries, one to the back of his arm and one to the back of his leg or the side of his leg, couldn't have happened if he was sitting on the couch. There's no way.
Mr. Menendez has this big gaping hole in the back of his head, as though someone had come to the back of him and blasted him in the back of the head. We know that there's a wound on Mr. Menendez's left thigh that comes in on the inner thigh and goes out on the outer thigh. If you take a look at the crime scene photographs, it's consistent with someone being behind. So after or before shooting Mr. Menendez in the back of the head, there's another shot from that vantage point.
Maybe he was turning or trying to, and in the middle of, he turned to the door because he was standing up, and then that's when the shot got into the inside of his leg. I don't know. I'm not a biomechanical engineer, which is what you would need to recreate the scene, and nobody did that. So you can't tell where the injuries came from.
Erik Menendez testified that he was always in front of the coffee table when he was doing his shooting. But we see that Mrs. Menendez had wounds on the bottom of her leg going upward in an upward direction to show that someone came around and was shooting her as she lay there. Craig Signorelli remembered about the pregnant wife, something that Casey Whalen didn't remember. Craig Signorelli testified that Lyle was to shoot the dad, and Erik indicated that he was supposed to shoot his mother. We know that Erik Menendez had to admit that he confessed to Craig Signorelli. He had to do that because there was this November 29th conversation, which the defendant didn't know was being taped, but which indicated that he had in fact made incriminating statements because he said, surely, well, you wouldn't have told the police what I told you. And now he wants to tell you, well, I didn't tell him certain things. I didn't trust him either. I didn't trust Oziel. I didn't trust Signorelli. Yet he tells him he kills his parents. Didn't tell either of them anything about any abuse, any honest belief in self-defense. Erik Menendez testifies at page 17,287 and 288 that he heard that Craig was telling people what he had told him. And he was mad at Craig for telling people something that he told him. We know that Erik Menendez claimed that this was the perfect murder to Dr. Oziel, and we know to Craig Signorelli he says, I've known from the beginning, no clues, no one heard anything. The only way to find me is through the guns in San Diego. Serious hitman. And as I've indicated, counsel tried to bring this up again, but there's no question that Erik Menendez came back on August 31st. There's no question about that. And if you take a look at Casey Whalen's testimony, he says at page 13,427 that he went to the house on September 1st, 1989 to pick up Erik Menendez. First he had to go to the house, then he went to the airport to pick up Erik. On page 13,428, he picked up Erik Menendez at the airport, then went back to the Beverly Hills house because Erik needed to pick up some things. He needed to get his messages and to meet somebody. Casey remembers a computer man but doesn't remember a wife there. I guess he was told that, well, there's a computer guy on that first. Casey didn't remember any woman there. Casey says that Erik Menendez kept his suitcase in Casey's car. They went upstairs, they came down, The guy met him at the foot of the stairs because someone had called them from Eric's upstairs bedroom and said, come on downstairs, there's someone here. Casey doesn't remember anyone else there. He says that the man was there about 30, 45 minutes. And he says, that was the first entire day that I spent with Erik Menendez, was the day that I brought him home from the airport. And Casey says, I don't remember the second day. He said he didn't know where Erik Menendez was on some nights, and that Erik made no phone calls during that day. And we then have his sister and mother come in and testify to basically the same thing. His mother, Catherine Bulow Cohen, says the night that Casey picked up Erik from the airport, went to dinner, Erik was talking about the computer. Casey picked up Erik, and it was September 1st, and Erik slept there that first night, and she's sure it's September 1st. And Katie Whalen said, yeah, he came home, and it was the 1st. And the reason why they had to say it was the 1st is because the expert was there on the 1st, and Craig Signorelli was there on the 1st. And they wanted to say that, well, Craig Signorelli couldn't have been there because it was Casey Whalen. We know that Mr. and Mrs. Heyman said, no, it was Craig Signorelli. Now, they don't know anybody in the case. They came in and testified as to what they saw that day. In fact, Craig Signorelli remembered the pregnant lady. Now, with respect to Antoinette Browers, Antoinette was one of the security guards for the Bel Air Patrol who was there. And she remembered one early morning having to go to Eric's room and knocking on the door and seeing Erik in the company of another male in the bedroom with their bathrobes on. And Mrs. Abramson says, well, we sent our defense investigator Early out there, and that's not what she called investigator Early, and Early keeps her notes. And, well, you know that we got some notes about Mrs. Valdry, a report about Mrs. Valdry. Remember Mrs. Valdry? She was the lady that got her pool serviced by Grant Walker on Saturdays. And she came in, and she testified, and she was cross-examined. Well, didn't you tell our investigator this? She said, no. I know when this man came to my house for the pool service, and it was 1987, for the first 2 or 3 weeks. He came during the week, but after that, the chemicals were okay, and then he came on Saturdays. And I remember that. No, I didn't tell your investigator that, Mrs. Valdry said. Well, they then bring in this investigator, the Cindy Early, to say, oh, no, she's lying. She was angry at us. And then when I finally got the report from her, read the report and says, this witness is cooperative. Well, who are they trying to fool? And now they want you to say, well, Early says that Ms. Browers doesn't know what she's talking about.
That was very confusing.
Because of the claims that the defense makes now, I find it necessary to have to go over a few jury instructions with you. One is you'll be instructed with respect to motive. Motive is not an element of the crime charge and need not be shown. However, you may consider motive or lack of motive as a circumstance in this case. Presence of motive may tend to establish guilt. Absence of motive may tend to establish innocence. You will therefore give its presence or absence, as the case may be, the weight to which you find it to be entitled. So there's no requirement that we show motive in the case. Show that there was an intentional killing, a premeditated killing, and that's all that's necessary. However, we've shown you reasons why the defendants killed their parents. Reasons being the relationship between the parents that preceded this killing, the burglaries that had occurred, and how the parents were disappointed in their sons and were going to disinherit them and disown them. And they didn't want to get disowned. In fact, you see what kind of spree they go on after the killings. Do you think they had any financial motive in mind? We don't have to show that, but I think that you can infer that from their actions. That's not a requirement. They're not charged with murder in the course for financial gain, certainly. Now, the defense claims that Erik Menendez is not the one who shot the parents, that gave the parents the coup de grace, so to speak. That Lyle is the one. Lyle is the bad brother. He's the one that shot his brother, or shot the father in the back of the head with a contact wound. He's the one that put the gun up to the cheek. So, well, Erik's not the killer then. There are two instructions with respect to that issue, and one is with respect to principles. The persons charged are concerned in the commission of a crime who are regarded by law as principals in the crime thus committed, and equally guilty thereof include 1. Those who directly and actively commit the act constituting the crime, or those who aid and abet the commission of the crime. Aiding and abetting defined goes as follows. A person aids and abets the commission of a crime when he, with knowledge of the unlawful purpose of the perpetrator, and with the intent or purpose of committing, encouraging, or facilitating the commission of the crime by act or advice, aids, promotes, encourages, or
Erik's not charged with aiding and abetting. He's charged with the actual crime. So how can you charge someone for murder when you're saying they're only aiding and abetting? That's not the same thing and shouldn't have the same consequences.
Instigates the commission of the crime, that person is guilty as a aider and abettor. The defendant didn't have to be the one to administer the fatal gunshot to either parent. He was a principal and an aider and abettor, and his responsibility extends to what Lyle Menendez does. Oh, okay. As I was indicating, the defense has brought in a lot of experts. We brought in psychotherapists, Tyler and Burgess, Vickery, and I think this is an interesting thing here. This has to do with the relationship between the defendant and his parents. And he's being asked certain things about what his motivation was. And now, did your mother and father, after you did the burglaries, did they see to it that you got some psychological assistance? There was an objection by Mrs. Abramson, which was overruled. The witness then said, we went to see Dr. Elzeel because my attorney told me that in order to get the best possible verdict from the juvenile court, that I went to, going into an attorney would play a large role. Now, next page goes like this. The court says, going to who? You said you're going to an attorney? Erik Menendez says, no, I'm sorry, going to see Dr. Elzeel or a therapist would be important to the court. So, what we have here is if it's a residential burglary, all you need is one psychotherapist to get you the best possible verdict from the court. But if you do a murder, you better bring in 3. And that's what they did. They brought in 3 to try to dazzle you so that you'll find them guilty of manslaughter rather than murder. I'm going to ask you to base your decision in this case on common sense and base it on the evidence that's presented. And as I've indicated, you may think that the defendants had a childhood that wasn't the best childhood, that the parents could have been better, they could have been nicer to them, but that is not a consideration for you. You don't feel sympathy for the defendant. You'll be instructed about that. That comes in another phase of the trial. The defense, Mrs. Abramson, tried to say that since the defendant felt remorse, he was having actually guilty conscience. He was actually seeing himself killing his parents in his own mind's eye. He saw the blasts. Who wouldn't have some kind of nightmare about that? You went in there and blasted your parents to bits. So he had nightmares, just like Macbeth had nightmares, but it didn't make Macbeth manslaughter rather than murder. He went in there and did the crime the way he did it. We can go to the prisons of the state and ask murderers, well, how do you feel now? You feel a little, have you had some nightmares about this? And someone may say, yeah. We don't say, okay, well, we're going to change it from murder to manslaughter. We don't do that. So I'm going to ask you to use your common sense.
His arguments are not even coherent or cogent at all. Like, they make no sense.
Not use any sympathy, not to use any thoughts that, well, he had remorse. That shouldn't come into play in this case, at least at this portion of the trial. And I ask you to find the defendant guilty of first-degree murder as to Jose Menendez and first-degree murder as to Mary Louise Menendez, and to find him guilty of the conspiracy to commit the murder, that there was this agreement, that the multiple murder allegation is true, and that the lying in wait, where they purchase these guns, they wait around, they wait for the opportune time to act, they wait till the maid's gone, they wait till their parents are in a vulnerable position, and they surprise them, and they burst in there, and they kill their parents. That's lying in wait. I ask you to find the defendant guilty as charged. Thank you.
All right, thank you. And what we'll do is
All right, so that's going to be the end of closing arguments. The judge goes into a very, very, very lengthy jury instruction, which I'm not going to have us listen to just because it's like over an hour long, and the judge is very long-winded. I'm also not going to show you the actual verdict reading because, again, the judge is very long-winded and it's lengthy. And I don't feel like there's a whole lot of value in doing that, where I could instead do a little wrap up here where we're going to do a wrap up of this trial and a little summary of the trial that follows. So here I'm reading about this is encyclopedia.com regarding Law Magazine's Brothers Menendez trials. All right, so we're talking about the closing arguments here. So the jury heard 6 months of testimony before the closing arguments began on December 8th of 19 93. Um, or no, it might have been 90. Yeah, 93 is when the trial started. All right. Um, I'm not reading you all of that summary. I wanted to start here. So Judge Weisberg's final instructions to the twin juries ruled out acquittals. The judge declared that the facts did not support a plea of perfect self defense in which a reasonable and honest belief that their own lives were in imminent danger led to the brothers to kill. The jurors had four options. If if it was agreed that the brothers had maliciously plotted to kill their parents, a verdict of first-degree murder would warrant the death penalty. Varying sentences could be imposed for convictions of second-degree murder, voluntary manslaughter, or involuntary manslaughter. If the brothers were found not guilty of involuntary if the parents were found guilty of involuntarily shooting their parents out of a genuine but unreasonable fear, they could be sentenced to a term shorter than the time served since their arrest. So they would have been likely released, potentially. So there were 16 days of deliberations in the Erik jury. And after that 16 days, they told Judge Weisberg that they could not agree on a verdict. Weisberg ordered the jurors to keep talking, but after nearly 3 weeks of shouting was going on behind closed doors, the jurors gave up. The Judge Weisberg declared a mistrial and released the jurors with a warning not to speak to the media. He did not want Lyle's unsequestered jury to be influenced. That makes sense. I mean, that's a good reason. However, 2 weeks later, on January 28th, Lyle's jury reported an additional 2 weeks from nearly the 3 weeks that Eric's jury had been deliberating. So almost 5 weeks it took for Lyle's jury. So on January 28th, Lyle's jury reported that it was also deadlocked. As weary attorneys on both sides watched, a second trial was declared. Los Angeles District Attorney Gil Garcetti immediately announced that the Menendez brothers would face a second trial for first-degree murder with no possibility of plea bargaining. No possibility of plea bargaining? Why? Strong disagreements over the essay claims had scuttled any chance for unanimous verdicts. With both juries stubbornly divided over the brothers' truthfulness, the final votes were scattered over the three most serious verdicts possible, each with its own implicit differing degree of guilt. Only one of the 24 jurors had voted for the least serious charge of involuntary manslaughter. Regardless of his intent, Lyle's testimony indicated that he had made most of the decisions regarding the shootings with his younger brother passively agreeing to participate. Yet Eric's jury had been the most contentious, with an almost even split between men voting for first-degree murder and women voting for voluntary manslaughter. The female jurors complained that sexist bullying and male jurors' homophobic suspicions about Eric's sexuality had prevented a serious resolution to the case. Like I was saying, the whole is Eric a homosexual or not? Who cares? It doesn't matter. It has nothing to do with whether or not the abuse happened. It has nothing to do with why these crimes happened. He's not, whether he is homosexual or not, which he isn't, it's not relevant. And it should have never come into trial. So defense attorneys Abramson, tough, flamboyant defense had kindled tension between her and Judge Weisberg throughout the first trial. That's an understatement. There were some really contentious days between the two of them. She continued her public assault on the prosecution after the verdict. She faulted the judge for his handling of the case and declared that no jury would ever be able to agree on a verdict. To prove her point, she invited the sympathetic women jurors to her home for dinner, a telephone chat with Erik, and an interview session with reporters about the stormy deliberations in the jury room. While her detractors accused her of being a media hound, Others marveled at her unabashed willingness to exploit the media on behalf of her client. Both critics and sympathizers agreed that publicizing her post trial dinner aimed to influence the jury pool while illustrating to the state that plea bargaining might be preferable to the time and expense of a second trial in which jurors might be no more likely to agree on a verdict. Prosecutors were not impressed. They declared that the defense strategy used so successfully in the first trial would be easier to counter now that it was known. Exactly. They showed their cards now, the defense, because basically the prosecution got a whole view of everything that was their case, all their defenses, or the best defenses that they put forward. And yet, the prosecution put forward their case. They had the opportunity to contest the abuse and the experts that talked about the abuse, but they didn't. They didn't interview Erik or have some kind of mental health evaluation for him. They failed on that. We heard the arguing there. So um, the prosecution didn't win because they didn't get their conviction. So why are we going again? Like I don't understand how we can keep retrying people in this country. The prosecution got a chance to go. They didn't get the conviction. So I think charges should not be brought again. That's my personal opinion. I don't care if people don't like it or not. It makes no sense that we're retrying people over and over and over again, trying to get a second, third, fourth, sometimes sixth bite of the apple. There's a gentleman named Curtis Flowers who went on trial nearly 6 times until finally, or maybe did go 6 times until finally, before the seventh one, the charges were dropped and he was released from prison. He was falsely imprisoned, wrongfully convicted, and yeah, happens often. All right. The prosecutors were not impressed. They declared that the defense strategy was used so successfully in the first trial would be easier now that they could counter that, so they have another chance to take the brothers down. They have a chance to defend the abuse and figure out where to go from there. So I'm sure their defense or their strategy for that was to eliminate talks of abuse during the trial, which is what they did. So those who had questioned the sincerity of the Menendez brothers' tears on the witness stand doubted that the defendants would be clever enough to convince a second jury of their emotional fragility. It was a costly trial. The trials cost the brothers their inheritance. The vast Menendez fortune was now depleted. Public defenders were appointed to represent Lyle. Erik pleaded with the judge for the state of California to pay his legal fees so that he could retain Abramson as his lawyer. The judge refused. After some grumbling about what a sacrifice it would be, Abramson agreed to stay on the case for a reduced fee. I hate judges that are just, they make no sense in their rulings. If the Menendez brothers had taken their parents' lives for money, their reward had vanished. In September 1994, the Menendez mansion was sold at auction for $1.3 million. The money was split between creditors and the county, which demanded restitution for the cost of the defendant's lengthy incarceration. Even their notorious celebrity dimmed. Although the trial of Hollywood Madame Heidi Fleiss, you guys remember her? She had customers like, I want to say, like Charlie Sheen and celebrity customers. So Heidi Fleiss and the Menendez brothers' second pretrial hearings were held in the Los Angeles County Courthouse. Both legal proceedings were largely ignored by the media, whose attentions had moved en masse to the O.J. Simpson murder trial being held in the same building. Coincidentally, Simpson had visited the Menendez family in the days when he was sprinting through airports in Hertz commercials. Jose Menendez, then a prominent Hertz executive, invited the former football star to dinner so that his sons could meet him. According to Vanity Fair, Simpson and the Menendez brothers did not meet until, quote, they were all in the celebrity section of the Los Angeles County Jail, all three charged with double murder. On April 3rd, Judge Stanley Weisberg ruled that the brothers would be retried together and in front of a single jury. So no two jurors or juries, and it's going to be a little different here. Judicial discipline and shifts in the defense strategy reduced the potential for sensationalism in the second trial, which Weisberg ruled would be heard by a single jury. The judge banned television cameras from the courtroom. One second. Sorry, I had a cough and oh, that was bad. Need my eyes water. All right. Still got a tickle. So he banned the cameras from the courtroom. Remember, this was like the 1993 trial that we just watched was the first time court TV put on a gavel to gavel present representation of a courtroom trial. So this was like their first experiment of that kind of coverage. So the second trial, which happened in 1996, the judge banned cameras from by restricting testimony only to events relevant to Erik and Lyle's state of mind just the week before the killings. The judge eliminated a potential parade of defense witnesses who were called in the first trial to bolster the brothers' allegations that their father was an abusive tyrant. Excuse me, I still haven't recovered from that. The most damaging blow to the defense was Judge Weisberg's ruling that the principle of imperfect self defense, which had previously been argued so effectively, was inapplicable. Citing a footnote in a Supreme Court decision rendered in another case after the first trial, the judge determined that the principle could not be applied to the retrial because the defense had failed to provide sufficient evidence that Kitty Menendez had treated her sons in a way that might have provoked them to kill her. Well, then you should have let them bring in the testimony about what she did and how she acted towards the boys. This time, neither Erik nor Lyle took the stand, thus eliminating any tearful testimony of abuse for their father and additionally negating the risk of being cross examined about the truthfulness of such accusations. I thought Erik did take the stand, so I must be wrong on that. All right, so on March 20th, 1996, after 16 hours of deliberation, a jury found, and again, 16, the number 16, it was 16 days, now it's 16 hours of deliberation, the jury found Lyle and Erik guilty of first-degree murder with special circumstances. So they found the lie in wait theory to be credible, which I just don't understand because all they did was open a door and go in the room. How's that lying in wait? But okay. Doesn't make sense. The verdict left the brothers liable to either life imprisonment or death by lethal injection. The jurors who had expressed uncertainty over the allegations of child abuse decided against recommending the death penalty. On July 2nd, Judge Weisberg accepted the jury's advice. The Menendez brothers were each sentenced to serve 2 consecutive terms of life imprisonment, thus bringing to a close, I disagree, a long and sad story of familial relations gone terribly wrong. As we know, the story is not over. It has not ended. That is not the close. And it shouldn't be the close because these boys were treated so horribly, which led them to the homicides. Therefore, they should have gotten a lighter sentence. I'm not saying that they should have gotten off completely. If it were me, that's what I would probably want. But if, to go with along with the jury, I would say let's do the manslaughter or whatever to get him, I'm okay with him serving time, but I don't want them serving 35 years for a crime basically committed to protect themselves. All they were doing was defending themselves. So I don't see the point of keeping them behind bars, especially when we know that they are very upstanding inmates. Like they have great records. They've created all these programs to help other inmates. They're doing this green project, which is beautifying the grounds where they have, they're planting trees and painting murals along the walls. So, and the boys have even stated, I think I read this in the last one, that they would want to continue their projects when they leave the prison. So if they do ever get out of prison, which, they're hopeful, but I think they're staying level-headed. Um, but what was my point? I think that they are, or they want to come back to the prison to do the green project and to help out with that. So I think it's awesome that they want to do that, and uh, it just shows what kind of people they are, that they would be willing to come back to the prison and work with the inmates that they've been working with and doing the projects that they've been doing. Because I see if I feel if they get out, which I think is highly likely, if they do get out of prison, they might tend to become huge celebrities and using that celebrity. I mean, they already are celebrities kind of in their own way, but I think that they can use that celebrity to really help victims of abuse. They can speak out, they can do, be motivational speakers, they can do presentations, they can go around, tour the country and speak on abuse and what it was like and how to survive in prison when you're put away in prison for so long for a crime that really was only there for, it only happened in order to protect themselves. That's what I think would happen if they get out and they choose to do this. I think that they could go on and really have a successful career in helping victims and motivating the youth, and go around and talk to children, youth, and tell them, if problems are bad at home, there's options that you can do, there's resources, and here they are, and give children more opportunities. I think that these boys can really make a big difference if they get out and use their celebrity to help others. And that's where I'm going to leave you today. This is not over. We're going to continue. I don't know if I'm going to have it ready for this week. So it might be next Tuesday, but I'm going to definitely have like some more follow-up videos on this, just kind of like where they're at, reunion videos, kinds of things. So this isn't over. This this isn't the closure that this encyclopedia.com says it is. I don't think. The closure would be having the boys come home. Uh, I think, well, I would like them to come home before the holidays because their family wants them home for the holidays. So that would be my wish. Contact Governor Newsom if you also feel that way. I did yesterday on Twitter. So um, definitely, get your voice heard if you want to say something about it. I encourage everyone to participate and get active. So, on that note, thank you guys so much for watching. It's been a blast watching this trial with you. It's been a horrific trial and learning the horror that happened in that house, but it's been fun going through and learning with you guys. So, hopefully, you guys learned something. I learned a ton, and I will see you.